All right, we're just going to give it a minute while people fill in, and then we'll go ahead and get started.
Sounds good.
All right, see it climbing. All right, looks like we're leveling off a bit. I'm sure people will continue joining over the first few minutes or so, but I want to welcome everyone. Good morning and welcome to today's CMFO Roundtable discussion. Thank you for joining us today, both our attendees and our panelists. We're excited to have you here. As a friendly reminder, I'll be sharing a few polls throughout the session to capture your attendance and for your credit, so please be sure to complete those when prompted. We want this to be engaging, so we encourage you to share your thoughts and ask questions through the Q&A feature on your Zoom toolbar. And if you have any sort of problems, just feel free to reach out to one of us and we will help you out. We look forward to hearing from you and having a great discussion today. And with that, I'm going to hand it over to Bud, John, and John, who will be introducing our discussion leaders and leading today's discussion.
Good morning, everybody, and thank you again, like Katie said, for joining us today for a few hours here. The topics are up on the screen, and we're going to go in that order with the GIF presentations first from Christopher Botta. Then we're going to go to Sean Canning for purchasing and green purchasing. Danelle and Matt are going to work on the legislative update, and I think collectively we're all going to kick in and chime in on the new local finances that are notices that are up. So again, thank you for joining us. It's a really nice day. I did want to throw one shout out to a person who's not even here today because it's their last day of work. That's my CFO in Hackettstown, Danette Dyer. Just wishing her a happy retirement going forward here. And liked working with her, going to miss working with her, but on to bigger and better things for Danette. So if you know Danette, reach out, let her know that she will be missed. So going into this, we're going to start off this morning with Chris Botta. Chris Botta is a managing partner of the law firm Botta and Jelly LLC, and he's a principal of CB Claims located in Ramsey, New Jersey. Chris has been managing and supervising liability claims for the Melgiv Fund since January 2012. Throughout his 30 years of practicing law in the state of New Jersey, Mr. Botta has significant experience in representing municipal entities and public bodies in various legal capacities. He has extensive knowledge in the area of risk management and municipal law, and is intimately familiar with the nuances of defending, assessing, and settling claims against municipalities and public bodies. He's a frequent lecturer on legal and risk management issues facing municipalities and public entities in the state of New Jersey. And he's located next to my alma mater, Don Bosco Prep up in Ramsey, New Jersey. So I had to throw that one in there. The commute from Little Ferry up Route 17 every morning for 4 years was remarkable. So without further ado, Chris, take it away.
All right. Thank you, John. From a Bergen Catholic graduate, I don't know, I can't get much for that introduction, but I do appreciate it. So welcome, everybody. I wanted to let everyone know that we're going to go through kind of the basic overview of the Tort Claims Act today, Title 59, and to give a little acquaintance as to how you can maybe protect your municipalities or your public entities with regard to tort claims that come in against you. And really, we're just trying to give you a general understanding. And of course, I have to give this, advisement. If you have specific questions, don't rely on me, rely on your municipal attorney. Their kids have to go to college too. All right, so because decisions of local government impact everything that happens in a community, almost any accident would result in a lawsuit against a town unless there is some reasonable limitation upon suits. Private entities, fortunately, have the ability to limit the scope of their activities and not do dangerous things such as garbage collection and mining and other things that municipalities do. Government does not. Up until 1959, you can move the slides, Katie. Government was protected by what's called sovereign immunity. Then the government, Supreme Court ruled that government employees could be sued for failure to perform ministerial duties, but not for their discretionary activities. Over the next few years, the court tried to determine what discretionary activities should have immunity, but finally they threw up their hands, as courts sometimes do, and said, let the legislature take care of things. The resulting Title 59 is based upon the California tort statute, something New Jersey gets from California, and actually this one is a good decision and good import from California. So adopted in 1972, Title 59 provides government entities with immunity unless there is a law establishing liability. So government can only be sued if a statute permits the suit. That's in theory, so not something that always happens that way. Katie, do you want to put up the question as to Title 59?
Yes, I will put that up now. Okay, so we're going to launch our first polling question, which is, how would you describe your understanding of Title 59 and its impact on municipal liability? And we'll leave this open for about 30 seconds for everyone to answer. I'm going to go ahead and share the results. All right, so it looks like most people have limited knowledge of it. Thanks, Chris.
Okay, all right. So we have some eager learners here on Title 59, it's something that you really can't ignore because it impacts a lot of your different things. So turning to the next slide. And the next one. So we have sovereign immunity and how it's put forth. But in terms of what Title 59 and suits against public entities are, 60% are common accidents filed under Title 59. That's the trip and falls walking into town hall, auto accidents involving police or DPW trucks, and other what we would call casualty or common claims. 30% of suits against municipalities are civil rights cases and employment practice laws. Those are the cases for, failure to promote or discrimination in the workplace that you read about in the headlines all day, every day. 10% are environmental issues brought under serious Superfund laws and environmental issues. So next slide. So under Title 59, all public entities in New Jersey, as well as their officials and employees, enjoy broad immunity for the exercise of governmental discretion. Discretion begins with legislative powers exercised by the state legislature, commissioner boards, I used to say freeholder boards, municipal councils, and boards of education. Title 59 provides specifically a public entity is not liable for legislative or judicial action or inaction, or administrative action or inaction of the legislative or judicial nature. Next. For example, let's say a pedestrian accident occurred after the council rezoned a property and traffic increased. The town's protected from a lawsuit filed by the injured pedestrian because the power to rezone or not rezone is discretionary and eligible for Title 59 immunity. Next. Title 59 extends immunity to employees, including special immunities for good faith enforcement or failure to enforce any law, the issuance, denial, suspension, or revocation of permits or orders, and the failure to inspect or negligent inspection of property. And really, without these immunities, a municipality would continually be sued on the theory that various accidents would not have occurred had the town enforced its law more effectively. Next. However, there is an exception. Nothing in the act shall exonerate a public official, an employee, from liability if it's established that his conduct was outside the scope of his employment or constituted a crime, actual fraud, actual malice, or willful misconduct. As you can imagine, there's a lot of variance in what this can be. And we see it a lot, especially in these more recent, and I'm sure you've seen the headlines on these sexual assault and molestation claims, where the towns basically say, hey, you know, things like that are outside their scope of employment and we shouldn't be liable. But aggressive attorneys try to make it so that it is kind of willful misconduct that brings us back into the scope of liability for municipalities. It's actually an interesting issue that will probably be going up to the Supreme Court in the next 6 months, because there's a difference in appellate division decisions on that, especially in the sexual assault and molestation area. So next. Another important immunity concerns recreational activities. The statute reads, a public entity is not liable for failure to provide supervision of public recreational facilities, provided, however, that nothing in this section shall exonerate a public entity from liability for failure to protect against a dangerous condition. So while there's no obligation to provide supervision, a municipality, employee, or even a town volunteer can be sued for negligent supervision when it is provided. Next. So the law does provide specific immunity for volunteer athletic coaches, managers, or officials of nonprofit sports team if they have completed a one-time safety orientation course, which usually is provided by Rutgers on an annual basis. So an important takeaway of this is that towns and your municipalities should require all coaches, referees, and other officials to submit certificates that they've completed this requirement, and they maintain these records in their town offices. Next. The area in Title 59 that is probably the most frequently litigated concerns accidents on public property. In order to prevail, a plaintiff must establish all of the following. 1, the claimant was using the public property with reasonable care for its intended purpose. So that's important, because intended purpose can sometimes be broadly interpreted, and we like to try to narrowly interpret it. You know, if you're walking on a sidewalk, that's an intended purpose. If you're riding your motorcycle on a sidewalk, that's not an intended purpose. 2, the public property was in a dangerous condition. 3, the public entity had actual or constructive notice of the dangerous condition that caused the accident. Finally, the action or inaction of the public entity was palpably unreasonable. Next. The courts have defined palpably unreasonable to mean behavior or actions or inactions that no prudent person would approve. Everything you see here in that slide has been deemed palpably unreasonable by courts. And really, the word palpably unreasonable is a nightmare term. Attorneys don't know what it means. Juries definitely don't know what it means. Judges hardly know what it means. So when you get to a point of trying to define what palpably unreasonable is, it's kind of one of those things, you know it when you see it and you hear it. So it's a very vague term and concept, and something that is very difficult for juries and judges to understand or apply in practice. Next. Title 59 also recognizes that governments do not have all the resources to do everything that should be done. And think of it this way. If you had your way, or some people had their way, you would put a police officer on every corner. The town would be completely safe. However, you have scarce resources. You can't put police officers on every corner. You can't put a stoplight on every intersection. You can't have brand new trucks every year that don't have mechanical failures. So a public entity is not liable for the exercise of discretion when, in the face of competing demands, it determines whether or not to utilize or apply existing resources, unless a court concludes that the determination of the public entity was palpably unreasonable. Again, there's that word, palpably unreasonable, a very difficult concept for in application. Next. So our takeaway from this, when you talk about scarce resources and dangerous condition, is that towns need to enact orderly infrastructure repair and replacement programs. For example, since most communities have miles of sidewalks, it's simply impossible to repair every defect. However, if the town decides to do nothing to maintain sidewalks, it may be held liable for sidewalk trip and falls. But if the governing body enacts a sidewalk repair program, say put aside 50,000, 100,000, 150,000 every year, and make a list of the most priority dangerous conditions on sidewalks, they can be protected, and the legislator meant for the town to have immunity during the implementation of this sidewalk program.
Hey, Chris,
Next. Yes.
why hasn't palpably unreasonable been defined, I guess, by either the courts or the legislature?
Well, they've defined it. They've called it, extreme action and, recklessness, carelessness. So it's been defined. However, in practice, the judges don't seem to want to make the decision. And really, it calls for a legal decision, but judges are prone to punt that decision to a jury, which makes it even worse because the juries have no concept of what a palpably unreasonable. They just think anything that's wrong or bad. However, I think the legislature meant to enact it as a higher level standard than just, a dangerous condition and you didn't do anything about it.
Thank you.
Okay. Next. So approved design immunity is another immunity. The Act provides broad immunity for injuries relating to a defective design of public property after it's been officially approved by an authorized governing body. This is especially important immunity because most streets were designed years ago using standards that are not consistent with modern practice. Most municipalities have old streets, old sidewalks, and they don't live up to the standards that would be, put forth by our engineering departments now. Without this provision, government would be sued every time someone alleged that an older road design contributed to a vehicle accident or a trip and fall. This immunity applies to any public project, not roads. So engineering, stormwater, that would definitely apply. Next, however, to take advantage of the immunity, and this is where the devil is in the details, the entity must establish that the design was in fact approved by the governing body or other appropriate authority before construction began. Approval must also be granted before any change orders. This should be done by resolution, so there is a permanent record of the action. And a lot of times, when we're defending cases like this, we know that a design was approved, and we hope that we can use the design immunity, but we don't have the records of it. Sometimes they didn't do a resolution, or it's 20 years ago and everything's been destroyed or somehow lost in kind of record maintenance. So the important part is make sure you have good records when you do a design project, and every change order on a street repair or sidewalk repair or engineering stormwater project should be memorialized by a resolution. And then at the end of the project, you should have a resolution approving the design and keep that with all your permanent records. Next. So our takeaway on that is you would need a system of regular inspections for litigation risk control, training for employees to identify hazards, make sure that you have a regular program of inspections. I would implement a procedure for employees or citizens to report hazards. We have that kind of with websites now. You can kind of have a maintenance log put in on a website, municipal website, and then procedures to log all reports and report corrective action. It doesn't mean you have to do everything the day that the complaint comes in. But if you keep a notebook or a log of how these things come in and then what you're doing to try to maintain it using your scarce resources, you'll be protected generally. All right, so the next biggest thing, and actually the biggest driver of litigation in our opinion, is police liability. Police is where municipalities are most frequently sued. Now, it's interesting, there is no requirement that a municipality maintain a police department, but this immunity prevents crime victims from alleging that the crime would not have occurred had the police been staffed or better funded. Another important immunity provides a public employee, is not liable if he acts in good faith in the execution or enforcement of any law. Nothing in this section exonerates a public employee from liability for false arrest or false imprisonment. So we can skip to 2. Next. So, for example, let's say an officer sees someone speeding but decides not to make the stop. 2 blocks later, the motorist runs a red light and has an accident. The officer would have immunity in this situation as long as there's no bad faith. For example, he was like on his phone or, texting his friends at the time. The officer has immunity in this situation as long as there's no bad faith. Change the facts and the results change. Let's say the speeding motorist is an off-duty police officer and he decides not to pull him over. A jury could easily decide that the failure of the on-duty officer to stop the off-duty officer was bad faith. Next, many police liability cases are auto accidents. Under Title 59, police officers have immunity when responding to an emergency so long as they are not driving in a reckless fashion. However, increasingly, police agencies are curtailing high-speed pursuits and responses to relatively routine calls such as burglar alarms because of the danger to both the public and the officer from high-speed pursuits. And really, I give these seminars to police departments throughout the state, and what we've been saying is just don't engage in the high-speed pursuit. It's not worth it. Because there are so many times that we get these cases where even if the officer disengages from the pursuit, the person they're following gets in an accident with an innocent third party. And usually the person who they're following, either a stolen car or somebody like that, has no insurance, and the police department in the town ends up getting sued. So these are the biggest drivers, and I would say in the last 2 to 3 years, the biggest increase in entity claims arise from police pursuits and the biggest payouts and settlements when it comes to that. Because again, a lot of times the plaintiffs in those cases are innocent third parties who are just driving along, or pedestrians who get hit by a speeding car, pursuing, going away from the police department. So next, the takeaway is that high-speed pursuits and responses are dangerous to both the public and the officer. And we're fortunate that the Chiefs Association in New Jersey, in increasing conjunction with the MEL, has instituted a statewide training program to reduce officer fatalities and serious injuries arising from police pursuits. And I would encourage you to inquire as to what you can do to try to improve those liability issues. All right, next we have a few other high-profile provisions. And to conclude kind of our little general overview, we should touch on a few other ones. First, there's a fire department immunity. There's a special immunity for fire departments and ambulance corps while responding in good faith any such services. Without this provision, the town would be sued after every fire, claiming that the damage was more severe because the fire department failed to arrive fast enough or did an ineffective job. However, first responders can be held responsible for conduct that is deemed willful or wanton, but this is very rare. And again, many of our communities have volunteer fire departments that may take a little time to get to the fire, so this is a critical immunity in Title 59. Next, we have a collateral source provision that reduces the amount of any award against a municipality by the amount a claimant can collect from other insurance. For example, let's say you park your new car on the street and it's totaled by a town truck during a snowstorm. If your car is covered by insurance, the maximum you can recover from the town is your deductible. Saves us a little funds along the way. Next, has sewer backups. This is another one where we use the collateral source rule a lot. If you can recover from your homeowner's insurance, maybe the town or the public entity only pays the deductible. And I know this is kind of the worst thing that an elected official or a government official wants to hear, is a 3 a.m. call that sewage is backing up into a resident's basement. The town has no responsibility if the blockage is in the lateral between the street and the residence. Under some circumstances, the town may have responsibility if the blockage is in the main line, so long as the town had some notice of the problem. For example, if the blockage occurred in the past with some frequency. So if it keeps happening and keeps happening, I would advise you to make sure it gets fixed so that you don't get hit with liability down the line. Next. So from that, you should know how your town responds to backups. Most towns have made arrangements where they can call in an emergency cleanup contractor to quickly clean up the sewage. This is much more cost effective than having to pay on a lawsuit 2 years down the line. After that, the adjusters sort out who's responsible to replace the damaged property. All right, next, under Title 59, there are strict time limits to file claims and then institute a lawsuit, and this protects us in a lot of different ways. Every year, there are cases that are barred because the attorney fails to file suit within the 2-year cutoff. Also, just for that, the deadline to start for minors doesn't start till they reach 21. So if your 14-year-old resident falls on the playground off the jungle gym, he can wait until he is 21, which is a little difficult for risk management because maybe we get the claim on that when they're 14, don't know if they're going to file suit for a long time after that because they have that opportunity. The other thing about time limitations is that a notice of claim must be filed 90 days after the accident. So if there's a trip and fall or an auto accident involving a police department, notice of claim must be filed within 90 days, and that's usually pretty strict, although there are some extenuating circumstances that allow that to be extended. But the reason for that is that, as a government entity with all these suits and all these potential claims, you need to know and be able to investigate it and remediate it if possible. And that's why they put a requirement for 90 days for notice of claim. Next, just going to briefly touch upon the sexual assault issues that are facing public entities throughout the state. The liability for sexual assault has been significantly expanded over the past few years. And as it stands now, victims who were adults at the time of the crime now have 7 years to sue from the date of reasonable discovery of the injury and its causal relationship. So what really that does is make it no statute of limitations. Because if you wake up one morning and realize that you were assaulted by a public employee, it starts to run from the time you realize or remember that you were assaulted. Victims who were minors at the time of the sexual assault can now commence suit 37 years after reaching majority or within 7 years of reasonable discovery of the injury and its causal relationship to the act, whichever date is later. In effect, the state of New Jersey has removed any statute of limitations on sexual assault and molestation claims against public entities. That's just the fact of it, and it's something we all have to deal with. They can also be sued personally if their actions or inactions were deemed willful, wanton, or grossly negligent. And the example of that would be, if you knew that the fire chief was engaging in inappropriate behavior with the junior fire brigade member and you didn't do anything about it or bring it to anyone's attention, you could personally be held liable. So be aware of those issues. Next, we have punitive damages. Punitive damages are barred in most Title 59 cases, and it cannot be covered by insurance. So if the actions or inactions are very extreme, and punitive damages could be awarded by a judge or jury, be aware that the insurance company, if you have a private insurance or a joint insurance fund, is not going to cover punitive damages, and the town or the municipality or the public entity will be on the hook for them individually as an entity. And that could be a big budget buster if that came to pass. And we've seen it come to pass most recently in stormwater management claims, especially in South Jersey. But they're happening all over the state. All right. So now we're going to turn to a interesting part of this seminar, hopefully, case studies. And we always have the little thing of here, those who cannot remember history are condemned to repeat it. So hopefully we can have you learn some things from the case studies that we're going to go through. And the case studies are also going to have a question answer period, so you can make a determination on your own, and then we'll see if your decisions were right. And now we'll get right into it. So, case study number 1. In the first accident, A motorist lost control of his vehicle at a dangerous curve that lacked a warning sign. The plaintiff was also able to show that the speed limit was entirely too high, and as a result, there had been numerous accidents over the years. The town was definitely on notice, but failed to take any action. Is the town going to be liable or not liable? Katie?
You guys should see that poll up now. And then I will share the results in about 30 seconds. Okay, make sure you get your responses in. Looks like most people agree here. All right. All right, you should see those results now.
Okay.
Thank
All
you.
right. Most people thought it was liable. However, next slide. In Kolich v. Lindendahl, the Supreme Court held that the town was still not liable because discretionary immunity applies to the placement of permanent traffic signals and signs, including the establishment of speed limits. Without this immunity, a town could be sued in almost every road accident, alleging that a sign would have prevented the mishap or the speed limit should have been changed. So again, even though they were on notice, they still get immunity. So that's a good thing and maybe a surprising thing. And that's hopefully you learned that. So the takeaway from this, however, once a sign is erected, it must be maintained. Further, the Act specifically provides that public entities can be held liable for failure to place emergency warnings. So if there was a dangerous condition and they knew about it and they didn't put out temporary warnings or signs or anything like that, you could be held liable. There are always exceptions to the rules. For this reason, police should carry temporary warning signs in the trunks of their patrol cars whenever needed. All right, next case. Maybe we can do a little better this time. In our second case, a senior citizen tripped on the broken sidewalk in a residential zone. The town knew that the condition on the sidewalk was serious, but did not have an orderly plan to fix sidewalks. Instead, the town passed an ordinance that required homeowners to fix sidewalks in their expense. Liable or not liable?
Wait a few more seconds. Okay. It's a pretty split one here.
All right.
Thank you.
Sidewalks are a very tough one here, so that's good. Okay, so in this case, next, the court ruled that the law makes a distinction between residential and commercial properties. Generally, a commercial property owner is responsible to maintain adjacent sidewalks. However, in residential areas, homeowners have common law immunity, and the entity that owns the road is responsible for the sidewalk, in this case, the municipality. So, liable. So that's always an issue that we talk about, is that the distinction between commercial and residential. Residential homeowners are going to be immune, and therefore it's going to fall on the municipality, even if you put in a statute or ordinance that says homeowners are responsible to maintain it. You can go and do it and repair it and then bill the homeowners, but you're going to be liable if somebody falls on a residential sidewalk. Commercial sidewalk, the municipalities have general immunity on that. Next. And that's where we talk about the ordinance there. All right. Common law. Yep. Snow and ice immunity. So while we're on the subject of sidewalks, under the common law, there's a very strong snow and ice immunity that applies to streets and roads. However, there are some exceptions. generally immune from accidents caused by snow and ice. There are exceptions again. Housing authorities don't have the same immunity. They have a higher standard that they need to take away with regard to snow and ice in their parking lots and common areas. And it does not apply to employee accidents in a municipal parking lot. Again, if you have a plan in place as to how things are going to be taken care of, you're in good stead, and hopefully you don't get a lot of those pictures like that guy falling with his Dunkin' Donuts going flying. All right, next case study. In a third case, foliage covered a stop sign and an accident occurred because a motorist who was unfamiliar with the area failed to stop. The town argued that it was eligible for immunity because it lacked the resources to trim all the foliage around town and around that sign. And I'm sure, if you're driving to work or anything, you see a lot of this, like foliage blocking signs. And of course, my practice has always been to like write it down because you see it and it immediately sticks out as a problem. But it's very common, especially you'll see in the springtime when the trees are coming up. So is the town liable or not liable?
Give it a few more seconds, make sure you get your responses in. Okay. All right, you should see the results now.
Good. All right. So majority said liable, and the answer is liable. In 1984, court ruled that the town was liable because leaving a stop sign obscured was palpably unreasonable. However, this decision only applies to the immediate area around the stop sign. So if you see something like this and it's blocking a stop sign or a yield sign or anything like that, and the person goes through the stop sign, the town will be held liable. It's a really, common thing that happens and that we see. So it's something that you need to train your DPW or your municipality or police department to call in issues like that so that they can be rectified. Next, you need to put a plan in place to correct hazards like this in the community. Okay, next one. This is an interesting one. In our fourth case, the county allowed people to toboggan down a path in a county park. The county knew that people were using the path as a toboggan run and also knew that at some point someone moved rocks to create a border down the path. In this case, one of the tobogganers hit the rock and was injured. I don't think we're going to do any more polling. We'll just go through it and we'll ask people to think about it in their heads. Is that right, Katie?
Yep, we're all good on the polls if you guys want to, yeah, you can put it in the
All right.
chat if you think one way or another, but yep, thanks, Chris.
Okay. So generally, there's immunity for hazards in unimproved property such as woods and streams. Title 59 provides neither a public entity nor a public employee is liable for an injury caused by a condition of an unimproved property, including but not limited to any natural condition of lake, stream, bay, river, or beach. And with our miles and miles of shore, this is an important immunity and one which we have used successfully on a lot of ways. We had, drowning cases, and those are unnatural conditions. As long as we haven't done anything to exacerbate those conditions, that immunity is pretty much upheld in New Jersey, and that's a good thing. But does not provide immunity for man-made hazards. So if you do something to add to that hazard, that's going to be a problem. So do you think the people were immune or not immune or liable for the toboggan run in the county? All right, the answer was not liable. In 1981, court ruled that the town was not liable because the fact that the rocks were moved does not change the general unimproved character of the area. So it's generally unimproved property, and no matter what you did around it, as long as you didn't make it extremely dangerous, it wouldn't have been overcome that immunity. Again, that's an example of how that unimproved property immunity is very broad and very protective of public entities throughout the state of New Jersey. It's an important one because, as I said, with shoreline, open space, public entities really cannot control and monitor every single piece of open space in their property. Again, it goes back to scarce resources and the reasons behind the immunity and the Tort Claims Act. Now, we can contrast that decision with the ruling earlier where a boater went over a spillway of a dam deep into a wooded area and injured himself. In that case, the court found the state liable for not adequately protecting the spillway, even though the area around the dam was otherwise eligible for unimproved property immunity. Again, that was a man-made improvement to a spillway or a river, so that was something that pierced the immunity. The rocks and everything were natural material, and the rock border along the path does not make the path improved property. However, a dam is a significant structure and not eligible for immunity. So as you know, these cases are very fact sensitive. One takeaway I want to touch upon on this is do not use immunity as an excuse to ignore hazards on your unimproved property. Sometimes judges grant the immunity even when the hazard was will not grant the immunity even when the hazard was naturally created. Again, it's very fact specific, and one that you need to basically take action if you see a dangerous condition. In one case, we had a couple walking along a path through town-owned woods during a windstorm with gusts up to 50 miles an hour. Again, would I say that that's using for its intended purpose? Maybe not. A hanger came down from a tree, injuring the woman. The case should have been thrown out under unimproved property immunity, but the judge ruled that the town should have posted a warning or closed the path during the high wind event. So again, fact specific, you need to be aware of dangerous conditions. Next. All right, another case study here. A young man dived off a county-owned bridge into a river, struck his head on a sandbar, and suffered a broken neck. A bridge is improved property and shouldn't be eligible for immunity we just discussed. The county had known for years that people often dove off the bridge but did not place any warnings and made no effort to stop the practice. Do you think the county is going to be liable or not liable? All right, this is again a tricky one. And again, if anybody knows Dave Grubb created all of these case studies, and he loves to trick people, get him with hard facts. So I'm not trying to trick anybody, but they are difficult cases, and we can blame it on Dave that we're all getting these wrongs because he likes to get everyone trapped on these and thinking about them. Anyway, next decision on that one is not liable. Why? Because the property wasn't being used for its intended purpose. Bridges are not intended to be diving platforms. And even though the county knew about the diving practice and what people were doing there, the court held that they were not liable. Generally, municipalities don't have an obligation to place lifeguards or post signs or police beaches, lakes, or other places where people may swim unless the municipality decides to protect swimmers by stationing lifeguards. They do have a duty to protect in town pools, though. So that's a difficult one. And again, this is a 1993 decision. Whether that decision would be upheld now, I don't know. There's been a hesitancy of judges in cases like this to grant summary judgment and uphold the immunity. So I'd be very careful. If you know of something going on like this, I would either put up a sign or try to prohibit it just as a general rule, despite the decision. Again, so the takeaway on that next is, next one. When a town acts to provide protection, appropriate warning should be posted. And when a municipality can be held liable for a lifeguard's negligence, that liability does not extend to natural hazards such as shifting sands, riptides, and the like. So If you have a lifeguard, make sure they're trained, but you're not going to be liable for things that happen that you can't control, such as tides or sandbars or things like that. All right. I think we have time for another one or two. Case study 6. The driver of a car involved in a minor one-vehicle accident on an interstate asked the investigating officer for a lift off the road or to call a cab. This was all before cell phones. Instead, the officer told the motorist to walk up to the next exit ramp to a gas station. The officer left the scene, believing that the motorist was capable of handling the situation and getting himself up to the gas station. Unfortunately, while walking on the ramp, one of the children with the motorist was killed by a passing car. The agency argued that the officer's decision was shielded under the Police Powers Immunity Clause. What do we think about that? Is the officer going to be liable or not liable? Okay, decision. The court ruled that the officer was still liable because law enforcement immunity in Section 59(3)(3) does not apply to negligence in the performance of ministerial duties. This was not a question about enforcing or not enforcing a law. The officer responding to the situation had a duty to protect the children and the motorist in this situation. Again, that's the decision and the distinction between ministerial and discretionary activities. Think of it this way. If you're negligent in doing the job that you're supposed to do, you're going to be held liable. If you're making a high-level decision, which is a discretionary act, purchasing extra protection for a condition in your town, making a decision about whether to engage or not engage with a fleeing offender, that's a discretionary act, which is going to be protected. In a more recent case, the court held that police officers were negligent in performing ministerial duties because they failed to look for a driver of a van that was wrecked on a guardrail. The driver died several hours later in a wooded area just off the roadway. Again, that's a ministerial job. Their job when they come onto an accident is to undertake an investigation. They undertook the investigation in a negligent manner by not finding that the guy had been ejected from the car and had drowned in like a marsh off of the whole roadway. So the officers were held liable for their negligent performance of their ministerial duty. All right, case study 6. Let's see. There we go. 7. Yep, here we go. All right. An officer responded to a call that an intoxicated person was in the middle of a major road, who subsequently left the roadway when ordered to do so by the officer. While the officer determined that the person was indeed intoxicated, he decided to take no further action and returned to his regular patrol. 3 hours later, the intoxicated person crossed the road a quarter-mile away and was killed by a passing truck. The person's family sued, claiming that the accident would not have happened if the officer had taken the person into custody. Now, there's a little trick in this one, another Dave Grubb insertion of why we trick you into it. The next one is under the Alcohol Treatment and Rehabilitation Act, the officer is required to take a person into protective custody if the officer has reason to believe that the person is intoxicated and is either a danger to himself or incapacitated. However, in 1989, a court ruled that the officer was not liable because the decision whether the person met the criteria requiring the custody under the Alcohol Treatment and Rehabilitation Act was a discretionary decision, not ministerial, and he had immunity. So again, it goes to the discretionary decisions or ministerial decisions as to how these issues are going to be decided. All right. I think that kind of wraps up kind of what I wanted to get through on our Title 59 discussion. And just to kind of wrap up, you know, Title 59 is complicated, and you really should take the advice of your local unit and municipality or county's attorney, along with professionals retained by your insurer or joint insurance fund. It's an effective tool to substantially reduce a government entity's litigation exposure. However, as we've said, documentation is critical. And I think the major factors rising in Title 59 lawsuits that I've seen over the past 2 years or so are one, police pursuit liability, stormwater management, and again, the sexual assault and molestation claims. So those are the big three, what I think of are going on right now. And, anything you can do to reduce your exposure, because they end up with large verdicts in a lot of cases. So anything you can do is an improvement for your municipality and public entity. All right. Any questions?
Hey, Chris, you gave a number of examples of, good thoughts for, keeping of records, maintenance of records. In your experience, what's it been like? Do towns keep these kinds of records? I know that's in general, but is there a good set of record keeping out there that the towns are doing, or is there room for significant improvement?
Well, it's like, in our 500 plus municipalities throughout the state, it's like with anything, there's good and there's bad. There's so many municipalities that are so short on resources that you really can't have a effective, protocols in place. You should, but it's almost impossible when one person is doing the job of borough clerk, borough administrator, maybe the DPW director at the same time. Trying to manage all those is very difficult. So yes, we see a lot of record keeping. Some could be better, but it's critical, especially with these large stormwater claims that we're seeing recently, where there should be immunity. When an engineer comes in and designs a stormwater system to alleviate conditions in various communities, if there are records to support it, a judge should throw out any claim for stormwater damages if the records are there. It's not always there, and that's the problem. So we have, the MEL has model ordinances and model resolutions that can be used to, put a bow on kind of any project to make sure that it can survive immunity challenges.
Thanks.
Chris, I almost guarantee that's lesser known. I'm sure the practice now is they tell everybody run with the job, they award the bid, but I don't believe you're gonna see many resolutions blessing the design before they go out to bid. That might be something for the elected officials course this year.
Yes, it's a good idea, and especially as we see it. And a lot of times you're going through the bidding process, your bid comes in, you have a challenge to a bid, you award the project, and kind of it takes on a life of its own. And you have your pre-construction meetings, and things happen, and all of a sudden your project's in problems, and then you finish your project, and you're just so happy the project's done. You don't take the time to, as I say, put a bow on it with a resolution approving the final design or any change orders along the way. So it is important and something that we should emphasize with our elected officials.
John, Steve Oraho's on the seminar, the webinar, and he had the same thought you had, that it was a good session for elected officials.
I would agree.
I'll pass it along the line. I know Dave will jump right on it.
Well, that and actually some of the clerks maybe get before them for their conference.
Yeah.
Hey, Chris, I have a question on to that point. That's the purchasing, and I work with a lot of engineers. They do the change. Well, everywhere I work, we do the change order resolution. So in essence, that does bless that along the way. But is there any immunity with the engineers by putting their seal on it, that they're a professional engineer, and them kind of blessing as a professional, or that doesn't come into play with having the council have to bless that design? Because there's always such a rush to get the plans out the door, and that's what I get all the time, which I can't stand. But it's like, you got to get it out now.
Yeah, no, the Title 59 doesn't provide, kind of blanket protection to professionals like that, or, have that go over to the public entity, because it's got to be the discretionary decision of the elected officials or the municipality as a whole. So it only applies if the elected officials or the municipality make that discretionary decision to bless the design or approve the design. Now, again, the design does have to be approved by the professional, so you can't have a negligent design or a bad design. If it's determined that it's a bad design, no matter how much you approve it, it's not going to protect you.
Okay, thank you.
All right.
I
Not
don't
seeing
see
any.
any, yeah, I don't see any comments or questions.
Actually, I served for many years with Chris when I was on the Mel, and I was on the claims committee, and some of the claims that you see come through are some of the craziest things in the world.
I would tell you just a quick one. We just settled a case. It was out in Morris County. County was doing a project, doing a tree trimming project on the side of the road. And they hired a contractor to do the tree trimming, but the county was in charge of the traffic control while the cars were going by. And you know, maintaining the one lane. I think they knocked it down to one lane while the tree trimming was going. The contractor, the equipment malfunctioned somehow. The saw blade on the tree trimmer shot off the saw into traffic, hit a passenger in a car driving by at a slow speed. I mean, talk about being in the wrong place at the wrong time. Hit him in the neck. The driver pulled over, saved his life because he was bleeding, and but the guy was just in the wrong place at the wrong time. There's almost no way to defend that case because the guy's an innocent third party just in the wrong place at the wrong time. That we made a motion for summary judgment trying to get out. The county, it was denied because they said you were in charge of traffic, maybe, and they had an expert that said you should have shut down the road when this was going on. But this is kind of something you can't plan or prepare for a saw to become disengaged off of a blade to become disengaged off a saw and hit an innocent bystander who was just driving by, wrong place, wrong time. But we ended up settling the case so that we wouldn't have exposure to a jury. Now, granted, our exposure wasn't as great as the saw, you know, contractor, but you know, we ended up paying on it just to make sure we didn't get in front of a jury on that one. So strange cases, and as John saw over the years, there were a lot of ones where you just shake your head and go, can't believe municipalities and public entities get faced with claims like this.
So Chris, how often do you succeed with summary judgment?
And maybe 25%, 25%. You know, a lot of times, especially with the judiciary now, there's a lot of turnover in the judiciary. A lot of newer judges are more hesitant to grant summary judgment on cases because they don't want to get overturned by the appellate division. A lot of the judges now are not trial attorneys who have been in the trenches. They maybe come from, you know, public agencies or internally in the government. So they're hesitant to grant it. So unfortunately, it's you know, declined a little bit over the years. It's a tool that we wish would be successful more often.
Sure.
Thanks,
Oh,
Chris. Do we
All
want
right.
to,
Thank you so much.
appreciate it. And I enjoyed the stories. I was wrong most of the time, by the way.
We're used to that.
I'll be sure to tell Dave.
Thank you, Chris.
You're welcome.
All right, so next up, we're going to talk about purchasing and green purchasing with Sean Canning. Sean Canning is a qualified purchasing agent consultant for 41 municipalities, joint insurance fund, and health insurance fund. He's also served as the QPA of record or consultant for 3 counties. Prior to establishing the Canning Group, Sean was the business administrator for the borough of Lincoln Park and the township of Mount Olive. His public service career also included time in law enforcement, serving as chief of police in the borough of Lincoln Park from 2004 through 2010, after rising through the ranks from 1985 to 2004. In addition to his municipal and procurement experience, Sean has taught public purchasing as an adjunct professor at Rutgers University, instructing students on procurement regulations and best practices to prepare them for the state exam. This part I find a little bit odd that he would admit this, but outside of work, Sean enjoys fishing, combing his hair, and attending happy hours. And that's not the odd part. Here comes the odd part. He is also a close personal friend of John Reinhardt and is still trying to become Jeffrey Lebowski. Sean, I don't know why you'd admit that, but I guess John was right when he said he had one friend. So we found him. And thanks for joining us, Sean, and it's all you.
Thank you.
For those that haven't seen Sean in a while, his combing his hair is funny because I think he spent most of his retirement watching his hair grow out, which is back in a ponytail right now.
Oh yeah, it's bad. It's longer than my wife's. So it's beach life. So when John asked me, probably in a vulnerable moment at the league, to do green purchasing, I had forgotten about this. It reminded me a couple of weeks ago, but it is a good topic. It's a very prescient topic because most of us in here have pressures from Sustainable Jersey. We got our credits through that. There is a component to green purchasing. I'm going to touch upon as many aspects as I can on that. Personally, I have to admit to some level of frustration with this, and it's not just with green purchasing, and I'm sure everybody here has it. And as Chris alluded to, there's always a rush. And again, I'm a QPA for a number of municipalities, and I have everything on autopilot. So usually if I get the specs, I can get a bid out the door usually within 15 minutes. It's just it's ready to go. But a lot of times, I'm always an advocate of like, let's wait, let's get a good specification. Let's get something good that's going to be out there, no matter whether it's green purchasing or any purchasing. But that budget churn is just nonstop, and the political desires and kind of goals, they want that project done now. We need that goods and service now. We need the road paved now, and it makes it very difficult for green purchasing. But I'm hoping to give a couple tools today that can, if you weren't the writer, then maybe get your engineers or your QPAs involved as far as the spec writing and getting good specifications. So I'm going to share some slides and some PowerPoints on here. Katie, I can probably share, right? Yes, I can. Good. And let's get that going. Here we go. So again, why do green purchasing? I'm on an anecdotal note, I'm going to give you one purchase in my private life, which certainly was green purchasing, and I was thinking about this. So I'm kind of in the middle of moving to a house I've been working on for almost 2 years here. So moving in there, and I wanted to get an irrigation system in the location here, and this was kind of a green environmental purchase on this. So most of where I'm at, and probably where you're at as well, the developments where they build them, whether it's Ryan Homes or Nanian, whoever, they'll put in irrigation systems, but often they'll tie them to the city water or the local water utility authority, and that costs money. This talk to different friends and them or their neighbors, they'll water their lawns, but that city water bill is just exorbitant. So in part of the move, I actually looked into it, and I actually had a well driller come out. So just to kind of give this is a nice concept into green purchasing. The cost of the well is approximately about $5,000. So to put that in, and then to run that, I can, they're 80 feet down. I can run this, 7 days a week, 24 hours a day if I want, because there's no cost to the water. Not that I would, but that will pay for itself easily within 18 to 24 months. And God willing, I'm here for a long time. I'll be able to water my lawn for the foreseeable future. So that green cost of just the one-time procurement and putting that in is kind of akin to the green purchasing. So I'm speaking to another friend of mine, Mike Capabianco. He's an administrator in Jamesburg. And he had come up with the same idea. We were speaking like last week, and there was a park that there'd been, trying to rehab, and he wasn't aware of this project. So the engineers and the public works, they said, well, we're going to run these lines, and we have to run power, and we have to do all this. And he said, why don't we just get a well driller and get that in there? And there was already electric somewhat in the proximity where they could run the sprinklers from there. And no one had thought about it, but that in itself is a green purchasing decision, because again, it just reduces your carbon footprint impact on the electric grid, on the water, certainly on the water. It's gotten more expensive. It is definitely a commodity now, and something that's only going to increase in cost as time goes on. So those are two quick examples. So why do we have green purchasing in the first place? Well, there's a couple reasons. Environmentally preferable purchasing reduces environmental impact. This has been a big push by the state of New Jersey going all the way back to 2006. Matter of fact, there's an executive order on this, and let me see if I can get out of here real quick, which the state put way back in January of 2006. So this is back in almost 20 years ago now. So this was the directive, and the municipalities kind of followed suit. And this was at the same time, if you were in municipal government back then, and I was, where the sustainable jersey first started growing its legs. And I think sustainable jersey came out first in about 2008, 2009, but that sprung directly from this time. And if you also remember back, you'll notice the local finance notices at the time. We went very much with the solars and the SRECs, and it was very, very new and confusing at the time, but it all stemmed from about this era. So in January 2006, the executive order from the governor directed state agencies to purchase environmentally preferable cleaning products that minimize potential impacts to human health, environment, can use up existing inventories. They encourage non-state agencies to do the same. And so that's where a lot of our green purchasing came about. And what we ended up seeing with the Rutgers classes and the QPA. So now there's that whole green component and the green CEUs as part of your renewals and as part of the basic program. The importance, it supports sustainability, reduces costs, and it complies with state regulations, which is why we're here. We all have licenses, especially in the QPA world where I kind of operate. It's in the local public contract law, so there's a significant role in this. So the legal framework for green purchasing, well, competitive bidding, green products, they have to meet fair competition standards. So this is another area I really want to delve into because writing specifications, and I get this all the time, and it doesn't drive me nuts, but I have to sit there and a lot of times say, hey, time out. And it could be not just for green purchasing, it could be for auto repair. And I'm gonna pick on you. Hey, you know what? We want to do a bid, but hire Bud because he's a good guy and we've had him for years. I'm like, okay, that's wonderful. If we have fair competition standards and Bud is the lowest responsible bidder, absolutely, I'm all for it. But a lot of times we have to push back a lot and say, listen, no one's going to jail for this. And green purchasing is no different because it's purchasing. As I said in my classes when I did the Rutgers certification, classes, it's very easy to get yourself in trouble. You're expending public tax dollars. So we have to make sure that you really, really are fair. You are the bulwark to keep other people out of trouble. And a lot of times the elected officials I work for thank me for that a lot because they don't know. And they're like, I'll gently push back, saying my job is to keep you out of trouble. And they're like, you know what? Do it the way you got to do it. And yes, I appreciate it. So again, back to green products, make sure we have fair and open specifications. Make sure we're comparing apples to apples. And we're going to get into some specification writing. Recycled and sustainable materials, there's a prioritization under state guidelines. A lot of times we can craft bids where we'll have our base bid, but there's nothing wrong with then doing an alternate base bid, which is more green product. And if we can kind of cycle those costs and compare the life cycle costs and other factors such as what they call opportunity costs. If it's taking our personnel, say at Public Works, X amount of hours at our average rate and benefits and salary compared to something that's more green, that has a better life cycle, we can make that comparison and come up with what's a better economic value for the organization. Energy efficiency and renewable energy can be incorporated into contracts. We make as part of our specifications. I'm going to get into Energy Star ratings. There's some very easy ways to identify in our specifications how we can kind of make this green purchasing and just better materials and products into our specifications. Here's an example of unfair specifications. All right, so we have to understand what's non-fair and not open when green purchasing. And again, this translates into our regular specifications as well. Key concepts. Well, fairness. It relates to equitable access for all potential vendors. Avoid favoritism. That is one of the biggest things I find in my day-to-day profession. And it's not through any malicious intent from anybody I work with. It's just human familiarity. And if you really enjoy a product and you enjoy a company, why wouldn't you want to have them continue? So it's nothing, like I said, nothing nefarious I'm dealing with. It's just, humans don't like change. And sometimes that bidding process forces change, or at least forces somebody to really sharpen their pencil. So somebody that we really like may have to sharpen their pencil a little bit more to keep that contract. Ensuring a transparent process. All my bids, a lot of them I do remote now. Sometimes I'll go on site, but if they're remote, I record everything, and I get Oprahs on it all the time, and it's transparent from the electronic bid opening right on through questions. I'll share pages with vendors. The vendors are all invited just as if we were in a conference room, but I record everything. I have a huge external hard drive that records everything and keeps the Zoom recordings. Again, that's just to ensure my integrity and also the municipality's integrity. Encompass ethical labor practices with the supply chain. Openness, emphasize transparency in the specification process, allows for broad participation. Avoid specifications that unduly favor specific products or manufacturers. It also means specifications that are not proprietary to one company. This is another area, and I'm sure the CFOs in here, you'll get this. I get this a lot. and this is, I want to clear up a couple of concepts or misconcepts within the state here. There is a process for proprietary in the state, and it's found in, I think it's the Administrative Code 5:30, Section 11, I think, or 8, one or the other. So if we find something that's truly proprietary, and I have to say in all my years, and there's been a lot of them, I think I've only run into maybe 1 or 2 proprietary systems, and I think one was the Newton Morris Reservoir Treatment Plant, which was built specifically by one company with its own controls, and the way to do that wasn't just to get a vendor to say, okay, they're proprietary, just put them on there, put them in a rec. We had to have a resolution passed to naming it proprietary. We had to put out a bid calling it proprietary. So you have to, there's a process in the LPCL. So if your bid writers or your QPAs are not aware of that, that's the process. What happens all the time, and this is where the nefariousness comes in, is vendors, and we'll get this more times than I can count, is they'll say, well, we're sole source. I see a chat. Friend of mine saying hi. So we'll get a vendor saying we're sole source. There is no sole source in the state of New Jersey. The answer is proprietary, and what they usually mean is they're a software company and they're sole source, where they are sole source to their product. With my esteemed partner, John Reinhardt, we're sole source if you want to make that a proprietary. When we do executive searches, we had written this entire Google matrix, which John's actually refined and made it even better now. But one can argue, well, that's a sole source and proprietary. It's not to the industry, it's just to our internal mechanism. So when somebody says we're sole source or proprietary, well, you are to your company, but you are not to the industry, and that's what the standard is. So some examples of non-fair and non-open green purchasing specifications: something that restricts product specifications, specifying a product only one company manufactures, even if there's functionality equivalent alternatives. So again, if we're going to buy a Ford F-150, well, okay, we can say that's proprietary, but it's proprietary to Ford. We know that there's an equivalent or better in the Chevy Silverado, the Toyotas, the Dodge Ram. So whenever we have something that names, there's nothing wrong with naming a green product as the manufacturer or equivalent. We have to know there's an equivalent out there, and that's easy enough with the internet and AI and whatnot. As long as we know there's an equivalent out there, you can put, again, Ford F-150 or equivalent. Lack of transparency, develop specifications without public input or stakeholder consultation, not disclosing criteria used to evaluate products or vendors. Geographic restrictions. Again, I'm not an attorney, and I'll defer to Chris on this, but I know there's a case out of, I believe Ridgewood, and I'll do this often in my specifications, and it has to do with, electricians where they have to respond to a water plant, auto repair, towing, and whatnot. We can put a geographic restriction, but we cannot put the geographic boundaries of your organization. We could put something reasonable, 10 miles as measured by Google Maps to a specific address. So that'll likely go beyond your geographic restriction, your geographic boundaries, but also ensure that somebody's going to be there. If they're 10 miles, they'll be there within 20 minutes, and that's something kind of reasonable. So when you're developing your specifications and we want to do a geographic restriction in order to get a product, a green product or whatnot, make sure that you measure something kind of transparent and fair instead of just saying the borders of the borough of Podunk. Favoring local vendors to an extent that excludes equally qualified vendors from other regions without a valid reason. Again, high transportation costs drastically increase projects' carbon footprint, that sort of thing. Energy Star ratings. Okay, we're all familiar with this. Shopping online, going to Home Depot, going to Lowe's. They have that yellow thing on all the utilities. The Energy Star ratings. So energy efficiency, it's actually easier to buy green on these than probably anything else. Because if we're looking for a new refrigerator for our lunchroom, in whatever organization we're in, microwave, whatnot. Home Depot has the state contracts. Lowe's has state contracts. Amazon has a national contract out of Omnia. Any of them. So as part of the purchasing, why not do an Energy Star rating and say, okay, we're looking for a good deal, but let's get something that is, rated, 4 or 5 stars or higher, and you can make that part of your green purchasing. And then you can also check off on your sustainable jersey. Do you engage in green purchasing? Yes, all of our internet-based Energy Star purchases are done with green purchasing in mind. So Energy Star ratings are annual energy consumption. They're measured in kilowatt hours per year. A lower kilowatt usage means better efficiency. Cost savings, again, you can justify the cost savings because the estimated savings over the appliance's lifetime compared to standard models. And the great thing is, if you look on these Energy Star ratings, they tell you exactly how much is saved per year by using this model as opposed to something else. So they do the work for you. Environmental impact, again, reduce greenhouse gas emissions due to lower energy use. Here they are by appliance type. And again, I would strongly encourage if you're buying these type of things in-house, and usually that's in-house. I don't get many of these where I'm QPA because this is kind of a department level driven procurement. But in the next, and certainly the towns where I'm very much involved in the staff meetings, I'll bring it up, and I have brought it up. But I would encourage you also to get this to your administrators and department heads that if you're buying something in-house and it's going to be a less than bid threshold cooperative purchase, make sure Energy Star ratings is kind of a priority. Refrigerators and freezers must be at least 10 to 15% more efficient than federal minimum standards. Dishwashers, they use less water and energy while maintaining effective clean performance. Washing machines consume less energy and water per cycle. Higher spin rates for better drying. Dryers, advanced sensors to prevent over drying, reduce energy use. Air conditioners, heat pumps. Again, this is a seasonal energy efficiency ratio called the SEER. And HSPF, the heating seasonal performance factor. Water heaters, electronics, and office equipment. Laptops, monitors, whatnot. So Energy Star ratings are across the spectrum, and they're very easy to research and make a good informed purchase.
Hey, Sean, you mind if I
Yes.
jump in here with the first polling question?
Sure.
Just gauging the audience here. Perfect. Thank you. You guys should see the first poll on green purchasing. Do you have experience with implementing green purchasing practices in your municipality? And then I'll share these results in about 30 seconds or so. All right, get your responses in. Okay. You should see the results now. Thank you, Sean.
Sure. That's a little bit higher than I expected. Hey,
Yeah.
Katie, I don't know if I had a question sent directly to me. I don't know if you got a question on chat. Can I address that real quick?
Oh, of course. Yes, I didn't even see that yet. Yep, go for it.
So there was a question, and it's not kind of related to this. It was how do we address police accreditation or RFP type of things? And it's probably the big kahuna on the block is Lexipol or the Rogers Group. So it depends. Lexipol has a cooperative contract out of Sourcewell, and if that goes over the bid threshold, you have to follow the national cooperatives, which I want to get into briefly at the end here. The other way, and I love competitive contracts, and it scares the bejesus out of a lot of people. Don't be afraid of them. Competitive contracts are just absolutely great, and I do them all day long, every day. They're terrific, and there's a process to it. Your QPA or your business administrator or your legal counsel has to administer it, just those three people per statute. But I would highly encourage that because you can do it for consulting, and that's what a police accreditation consultant is, and there's a whole process to that. The competitive contract, that's a whole nother subject matter, which I can get into. But I would highly encourage doing a competitive contract for a consultant. The great thing on that is when you're done, it's a 5-year contract if you want, and you're done. I love putting contracts to bed, getting them off the table, doing them right, and be done with it. So I would, for the person who asked that question, I would encourage the competitive contract process. Okay, so Nev, I'm sorry.
1% before we move on, the 5-year statement you made, but you can also chunk that up into smaller increments, right? You can do a 2 and then 3 1s.
There's varying, as you know, my rosy relationship with the Office of the State Comptroller has disagreed with my take on that. So I would preface it this way: if you're not going there, sure, that's my own take on it. If you're going there, they want to see right off the bat how much you're going to do, and they don't care about extensions. They don't care about a lot of things, to be honest with you. But they want that number right up front.
Gotcha. Thank you.
Don't get me going. Navigating green purchasing for public projects, competitive bidding specifications have to be fair and clear. We've touched upon that. Lowest responsible bidder, sustainability criteria should be embedded in there. Specifications and or equal clauses, that is right in the local public contract law, equivalent or better. It's right in there, and that throws the onus on the manufacturer, which I love because and make use of it. They're not just words. Make sure that you put that out there and then use it. If somebody and I've had this. So, and I think it was with another water or sewer utility plant project, and we had put equivalent or better, and somebody came back and said, "Yeah, we're equivalent or better." So I engaged our water and sewer engineer, and they came back and they looked at everything up and down, and they said, "Yeah, they're equivalent or better." Guess who won the bid? So when you do or equal, Again, we don't have to know that. We're not the subject matter experts, but make sure that somebody, one of your professionals, usually they're engineers, who I have a huge respect for, engage your subject matter experts and make that determination of an or equal. And there are times where somebody can jump up and say, yeah, we're better than or equal. And if they can come up with that opinion, yeah, and you save money, then we're all good. Life cycle cost analysis, justify higher initial cost for long-term benefits. I gave the example of the well in Jamesburg and also in my backyard. It's a higher cost, certainly for 1 year, but over time, that bill's done. I'm never paying for that again. So that's again, that's a life cycle cost analysis. Product A, again, we'll do the Jamesburg example. Personal labor costs versus a green product with possible less labor costs. They have a set irrigation system with a well and they ran electricity and they have it on a timer. There is no labor cost. Meanwhile, a lot of our towns and probably in yours, you're going to see the summer help out there hauling sprinklers and lines and then going back and get it at the end of the day. If you calculate that over the cost of a summer, again, summer help is generally cheaper than your full-time folks. But that labor cost you can calculate and come up with a number. And if you extrapolate that over, 1, 2, 3, 4, 5 years, there's likely an alternative that even though it might be a capital project up front, would reduce or eliminate those costs long term. Green purchasing, examples, infrastructure and equipment. Sustainable pipe materials, HDPE pipes with recycled content. Okay, that's a pipe material as opposed to the traditional other products. Low impact concrete, use of supplementary cementitious materials. Say that fast. Energy efficient pumps and equipment. Again, that's Energy Star rated products. Green infrastructure components, permeable pavement, bioswales, rain gardens. I see rain gardens. I used to bike a lot at, was it Lowentonka Park? I think it's over like Morris Township, that area. And they have a bunch of rain gardens there. It's pretty cool. So what they do, instead of diverting it into the storm drains, they put these rain gardens there, and they're great. And they act as filtration for the water runoff. And this was less going into the storm drains, less getting the fertilizers and runoff and, killing the fish in whatever stream. So again, rain gardens are a great use. Plus, they're very attractive. I like gardens, I like that sort of thing. So it's nice to say. Construction waste management, contractor recycling, reuse requirements, food composting. I remember we'd done a study in the past. John, I think you were in on that, where I think we calculated, I think we were doing the Hoboken examination of their whole recycling, everything in the world of Hoboken. I think food waste in restaurants was something like 35 to 60% of the weight of solid waste going out. So again, that's a great area where you can reduce costs. Sustainable erosion sediment control, biodegradable erosion control products and whatnot. Office fleet and landscaping examples. Green office supplies, recycled paper. Okay, it's you go on WB Mason, they offer all this stuff, especially if it's paper that's just some people print everything still. I don't. But if you're printing stuff, why use the heavier weight, more costlier paper? If you got to do recycled paper, except for the ones that really matter to go into reports or your governing body or whatnot. Refillable cartridges, non-toxic cleaners, renewable energy and efficiency, solar panels, LED lighting, that's all pretty much everywhere. HVAC systems, it's very good because it is the standard nowadays. Electric and hybrid vehicles, there's a lot of that going out there. Municipal fleet transition, charging infrastructure, you kind of see everywhere in New Jersey with the fleet chargers. You got to be careful if you have certain vehicles and it's getting damaged nowadays. But outside of that, you see a lot of electric and hybrid vehicles out there. It's certainly kind of been changing the way municipal fleets are being bought. I've actually did my first electric garbage truck in the city of Englewood, and that was a challenge, but it was pretty cool. Sustainable landscaping, native plants, organic fertilizers, water efficient irrigation, like we said. Back to irrigation, it's kind of neat. If anybody has irrigation systems on these apps they have now, it's John probably has it. They have the smart watering and the thing where this has been around forever, but they'll have the sensors out there if you're scheduled to irrigate today and it's raining more than a quarter inch or whatnot. They'll the system, it knows that it's not watering today. So it's pretty crazy. Implementation strategies. Well, a lot of us have it in here. I would venture to say, and actually this might be a good poll question, Katie, on the fly. How many people do Sustainable Jersey? Because Sustainable Jersey has a whole section in there for credit of sustainable purchasing. So if you don't have, or you do have sustainable purchasing and you're not aware of it, it really is, it's in there. So your QPA should be aware of it, or your BA. If not, then whoever your green team is out there certainly is looking at this. And if you haven't implemented that, there is a small portion or maybe a larger portion of purchasing that can go towards sustainable Jersey and green purchasing. So develop green purchasing policies. I would think almost everybody has one because that's part of the sustainable Jersey. So this is going, I remember writing ours for the Borough of Lincoln Park back in 2000 and I think it was 9. And it was, there was the purchasing policy amongst all the other policies. My mayor there, Dave Runfeld, if you know him, he's a great guy, and I worked for him, and he wanted to get the Sustainable Jersey Award. So I was the administrator back then, and had to lock myself in an office for basically 2 weeks and write policies for Sustainable Jersey and get everything rolling. But we did it, and it's kind of get the ball rolling. So your green purchasing policies are in there, and they have procurement priorities. Incorporate sustainability in bids, embed environmental standards in procurement docs. And some of them that can be done, and it can be easier now than ever. Again, I'm going to pick on John again. The AI. So he and I speak about this. I don't know how many people in here use AI, but it is just it's awesome. It is great. I use both Gemini and Chatbot. So where I'm going with this is if your engineers and your QPAs or whoever your specification writers are, make use of AI. It is just absolutely a godsend. Now you have to know your stuff because like ChatGPT, the free version, has been updated since 2020. So a lot of times I'll do research and they'll reference stuff, including local finance notices, which are incorrect. So you have to know your knowledge before don't take it just as rote diction. So you have to go through line by line and amend things to get it to your organization, also to your intent. But by and large, they're very well written. It gives you a basis of a technical specification. And what you can do, you can just ask us, saying, hey, we're looking to buy whatever widgets, in a green fashion. And it just scours all sorts of stuff that standards that you don't even think of. And like, wow, okay, I can include that in there and then kind of tailor that specification. So it's an easy way to incorporate sustainability into bids. The big frustration, again, for me, and I'm sure for the CFOs here and QPAs out there, is the projects have to get done. We got to get them out the door. The next council meeting is April 3rd. We got to get it on by then. So it's just a constant push to get things done. Whereas I always think, not that we have to be sloths in this, but if we take an extra couple of days or an extra week, we get a better specification, we get a better bid, we get a better price, and we get a better product. Easier said than done. Leverage state-approved green contracts. They're on NJ Start. They're all over the place. So again, a little research. Educate procurement officers and vendors. Well, that's what we're doing today, and this is done. I know the Rutgers forums. If you've been to they have one coming up in April down in AC. There's always green purchasing on the certification seminars. Monitor and report impact, track sustainability metrics. All right, challenges and solutions. Again, I think the number one, I wish I put it in here, is just the pressure to get things done. That is the biggest, the cycle of just getting things off because everybody's just moving, trying to get more done with less personnel, less budget, and still get things done. So there's just this constant whirlwind. Cost concerns, use of total cost of ownership analysis. We explained that before. The irrigation system, how much is your public works folks setting up, taking down versus if we expended a capital project and put in wells. Limited market availability, suppliers and cooperative purchasing. The private industry responds to market trends. So there's a lot more sustainable products out there, and that's just responded to the economic pressures. Some of it's pushed by government subsidies, but there's others where they just have to compete and they'll morph on their own. Regulatory compliance, align with the LPCL, the local public contract law, to avoid bid disputes. Conclusion: green purchasing supports sustainability while maintaining compliance. Public agencies can reduce costs and enhance environmental impact. Commitment to responsible procurement drives the long-term benefits. Okay, so I'm gonna segue real quick. Katie, did you want to do another poll at that point, or you want to wait?
Yeah, Sean, that would actually be great. I did just add the one you mentioned. Does it make sense to ask, has their municipalities participated in or achieved certification through the Sustainable Jersey program?
Yeah, I think that'd be great.
Great. All right, I'm gonna launch that. Everyone should see this poll question now. Great, I'll give it a few more seconds and then I'll share the results.
John, you're right, though. The AI definitely helps a lot.
Oh, it's just awesome.
I use a lot, even if I'm just thinking about something, I can't get the words together. You just throw it in there and ask it to approve upon it.
Mm-hmm.
We did that this year with all of our capital budgets. The department submitted with 268 capital requests. But the descriptions were horrible. So Melissa Howard, the treasurer, took every one of the descriptions, put them into ChatGPT and says, expand upon and clean up the language. Did a wonderful job.
Wow, that's a lot. That's more than expected.
Thanks, Sean.
Thank you. That's more than expected. I thought at one point it was super high. It's you know, I might be dating myself back when I was administrator. There was a big push back then. All right, I want to jump into national co-ops, and almost everybody uses them. This is definitely one area which kind of drives me nuts a little bit, mainly from the vendor side. And we've probably all used national co-ops. And what I get, I'm going to delve into some of the details on this. So as a little historic thing here, before 2012, and it was very frustrating, the state would not allow us to use any national co-op. You just couldn't do it. And finally, in 2012, it was actually a public law 2011, which allowed us to do it, but they put out the LFN in 2012. Before that, it was really difficult because ESC&J might have been around back then. You had the state, contracts, Somerset. I don't think Bergen was as big as they were then, John. You had Morris if you were adjacent to Morris County. So there was just a lot less cooperatives and places to go shopping in the state, and we couldn't use nationals back then. So it was a huge frustration point for purchasing. So lo and behold, 2012-10 came around, and the state allows us to use it. But this is the process on this, and you should be aware because I think a lot of towns aren't. And I'll tell you how I arrived at this, and it's more anecdotal in nature. But there's a lot of steps the state requires us to do before we can use the national co-op. And what I get all the time is from vendors, and I get it because I don't like being Dr. No, but I'm Dr. No sometimes, and I have to be. So I'll get a department head saying, "Hey, I have Joe Schmo from wherever," and he says we can use John Reinhardt's Honest Cooperative from Wyoming, and why not? Because and they'll name 20 towns that just went ahead and used this. I'm like, okay, good. And I don't want to disparage any colleagues out there, but they're not following the law. And I'll tell you right now, and I'll list how it's done. So, and then instead of being Dr. No, I'll say, we can do it, but this is how we have to do it. And that vendor usually means they're not getting the contract because they've somehow, bamboozled the department head into thinking that they're the best and we just have to use this person's company. And that's where a lot of frustration comes in. It's always driven by vendors because they'll find, it's almost like kids. Well, mom said I can do it. Why can't I? They'll trade parents off against each other. So the vendors will do the same thing because their sole purpose is to separate you and the town from the funds so they can get it. That's their sole job, and I don't blame them. So they'll do that all the time, and I must get this at least once a week. Well, we do this in this town, and again, I don't disparage the person there. I just say, well, we're following LFN 2012-10. So let me get into this as to how it's supposed to work and what really happens. So there's a couple issues here. So all the elements of the notice apply to aggregate cooperative procurement above the thresholds. A common issue, number one, the law mandates for purposes of this paragraph, the contracting unit. Okay. So this is somebody putting out the bid. So a national co-op means any county, municipality, special district, school district, fire district, any board, commission, yada, 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 which has administrative jurisdiction over any district, including operating in whole or part within the territorial boundaries of any county. So this is right from the local finance notice 2012-10, which I have. I'll pop it up on the screen in a minute. So it's right from the local finance notice. What this means is a national cooperative, and I'm going to name two that automatically comply. There is Sourcewell, which is a subset of the state of Minnesota, very much like our New Jersey Division of Purchase and Property is a subset of the state of New Jersey, automatically complies. When they put out a bid, it is a taxing organization. In that case, it's a state. So they're putting out Houston Galveston Area Cooperative, subset of the state of Texas, absolutely, boom, they got it. So the law mandates that whoever puts out the cooperative has to be a contracting unit. It's the same as if, I'm going to say Morris County, the Morris County Cooperative Pricing System or Bergen County co-op, it's put out by a governmental organization, a unit. Therefore, that co-op automatically makes it, fair and open. A government unit put it out there, and then there's some other things that have to go on there. Many cooperatives don't have the contracting unit as their basis for procurement, so I'll give you some that are out there. Omnia is one. Omnia is a really good co-op, but Omnia is not the contracting agency. What Omnia does is they're an aggregator, and a lot of them are aggregators. And Omnia is a pretty good aggregator. They'll get co-ops from, I've seen, oh my God, so there's a county in South Carolina. We'll get Maricopa County in Arizona. You'll get Prince William, Prince George County, Maryland, and Virginia down that way, and they'll put it out there. And it's not just for their purpose, but also for an area of the country that's extended to, including New Jersey. Then we can use it. So when somebody says, "Hey, I have a co-op," okay, who's the co-op? Well, it's I'm going to pick on Tips. Tips is one of them. There's another one out from state of Washington, which I never heard of. And I'll get this all the time, and I'll look into it. A lot of them will use what's called a Region 14 ESC out of Texas. Region 14 is not an ESC like our ESCs. It's not supported by taxpayer dollars. It's kind of akin to like a Boys and Girls Club. So that's not a taxing unit. So I'll push back a lot of times going, can't do it. I'll tell you why we can't do it. I've had discussions with Omni on that. So it's very important when somebody says they have a co-op. Okay, who's the co-op, and what is the source of that bid? And once we pass that, then we'll get into, again, I just said a lot of this. Subset of state or local government, Sourcewell, Houston, Galveston, aggregator of cooperative contracts, Omnia. Okay, prior to use, we have to do some detective work. We have to pull up the original bid. What does it look like? More often than not, I'm like, yeah, we're good. Do we have to get down there? So, and the second part is it has to go through a competitive bidding process, which means they have to do a bid. It's an open competition among those submissions of bids, award to the lowest responsible or most advantageous to the public entity, price and other factors considered, some sort of public transparent procurement that would mirror New Jersey. So New Jersey mandates that they have that fair and open, and New Jersey local public contract law is really a good law. Everybody's like, oh, it's a pain in the neck. Well, it's a pain in the neck because we've had so many people go to prison through the years because of this, that we had to put it into legislation. And I think it's one of the best laws out there, really is. Excludes contracts awards based upon invitation only, negotiated, local preference, sole source, and whatnot. Types continued. Contract being awarded pursuant to national cooperative must have been awarded by a contracting unit. Okay, we went through that. Like I said, Sourcewell and HGAC automatically comply. Original bid must have been advertised as a national co-op. Okay, so it has to be advertised. A lot of times I'll jump into Omnia procurements, and they did one for Amazon, which is a good example. And they did a national co-op procurement on that, and they have the advertisements. The legit co-ops will have all your transparent advertisement, much as we do with a bid in our own local organizations, where the clerk will send out to the papers now. In other words, when a salesperson says they have a national co-op, there has to be some detective work prior to use. Many co-ops do not qualify and they can't be used. And I can't tell you how many times, I'll get to this in a second, how many times I see just a resolution thrown on from a national co-op, and there's no notice of intent. There's no 10-day advertisement out there. There's no fact finding. They just treat it as a state co-op, and the law explicitly does not allow that. And yet you see it time and again. Common problem number 2, failure to obtain New Jersey-centered documents prior to award. The auditors will go through this. I get questioned a lot. Hey, where are the documents on this? One of my clients just went through the Treasury PAYCO examinations, and it was pretty rough on them. It's the first time they had been through. One of the things that Carlos Anthony in this case specifically was looking for was the Sourcewell SEER or AA302, and then putting into the Treasury for the SEER. So when I say the SEER, it's the gold like 3x5 document a vendor has. So if they do an AA302, that's a placeholder. It's an application that's got to go with $150 down the Treasury. Within 6 weeks, they'll get that golden certificate back. But all these documents. So once we say, okay, we're going with a Sourcewell contract, well, the vendor has to supply a New Jersey BRC. If they don't, no can do. Can't do it. Okay, if they don't want to have New Jersey business reg, can't do business with it. EEO compliance documents, ownership document, and now the Iran form and the Russia form. So all those documents, I have the department heads reach out to the vendors, send it back, becomes part of the case file. Pay to play is not needed. I can't screen this as much as possible. Pay to play is not needed. Pay to play is for we're talking about the BED-C, the business entity disclosure, and the PCD, the political contribution disclosure forms. That is only needed for a non-fair and open required disclosure procurement. Anything that is a public bid that's been fair and open, advertised, pay to play we've already satisfied it. It's a fair and open. Common problem number 3, failure to determine a cost-saving statement. Now, this is tricky. It used to be very easy, so it's gotten a little bit more challenging. So when back in 2012, when we first started doing this, I'd very easily be able to do a search and some resolution, we'll say, for a Elgin street sweeper. And somebody in South Jersey would have done a bid, or they got it through a state contract, and it was $83,000. Well, I know that our national co-op coming in is at $79,000. I was able to just reference and attach the resolution from somewhere. Everybody buys off of national co-ops now for the most part. So it's much more difficult to find that cost savings. So you're gonna have to get a little creative in your cost savings statement. especially with fire trucks. I kind of find it a little bit easier because if we're going to sit there and bid our own fire truck, you're going to have to get a firematic consultant and expert in there. The development of specifications is a lot of money. It really is. And not just your consultant in there, you're going to have your legal counsel, whatever their billing rate per hour going over that. Yeah, your labor hours by your administrator, your QPA, CFO, anybody else is in there. So the development that, excuse me, can all go into that factor, as well as examinations. You're going to want a firematic consultant to look over that truck when it's delivered. You're going to probably want a firematic mechanic to go through everything. Product testing, all those hours and those costs can go into development of a cost. That cost likely is going to be higher than what you're going to be getting with a fire apparatus out of HGAC. So that's a little bit easy, but that same concept can be used for other things where your own labor costs, your professionals costs in your organization, how much is that costing versus what you're getting out of the national co-op. But there has to be a cost savings statement. I always do it in what's called a fact sheet. So I have all the, when we join, what's the resolution number, who's the vendor, what's all their information, all the backup. I'll send it to the municipal clerk, and it's just file upon file. But this way, it's nice and easy for Nisivoccia to come in and go, okay, yep, file complete, moving on. I touched upon all this. Common problem number 4. Failure to publish a notice of intent to award. So the law demands for national co-ops, the bid thresholds, now it's above the bid threshold, not under. So any procurement above the bid threshold requires a notice at least 10 days prior to award. Again, with the cycle of things, hey, the council's on, the meeting Monday. I've had this, I say this in my seminars. I do seminars for my clients at least 3 times a year. And I joke around because inevitably I will get it on a Friday afternoon. Matter of fact, later today at like 5:30, going, hey, Sean, the meeting's on Monday. Can you bang this out over the weekend? Because you're not doing anything. And then like, no, it's 10 days prior to award. So part of it is we have to do a notice of intent. It goes out 10 days prior to award. And then we could put the resolution on. Very similar to your pay to play. Your documents, they have to be into the municipal clerk's office 10 days prior to any action by the governing body. I know there's exceptions, but that's what the law requires. Many organizations treat the national co-ops just like in-state, and they just do a resolution. Your notice has to contain the name of the entity that's awarding or awarded the contract, title of the contract, a web link to where the contract can be viewed online. I always have it, whether it's Omnia, Sourcewell, HGAC. Length of the contract, all right, must be consistent with the length of the public contracts law regulating the contracting unit. Statement naming the vendor to whom the contracting unit intends to award the contract. Statement of the authority, that's the authority's was public law in 2011, and it's encapsulated in NJSA Title 52. And a notice of when the comment period ends. I usually have the comment period ending on the date of the award by the governing body. I have samples of this. If anybody needs something offline, let me know. I'll be happy to share them. Common problem number 5. This is a big one. So for those of you that are going to do, turf replacement, Musco lighting. Now, Musco has a ESCNJ contract, but as a matter of fact, this is a great example. It wasn't more than 2 days ago. Somebody from Musco was not complaining to me, but complaining to me that that a lot of towns use national co-ops, and I just kind of sent back. I think it's page 8. It's an LFN 2012-10. It's in page 8, section F, and explicitly says the use of national cooperative contracts only applies to contracts for goods and services. It does not apply to public works and construction contracts. This is a theme I'm constantly always hitting on the seminars with my clients, saying, please, 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 I don't care what the vendor says, we can't use it. And again, I don't want to be Dr. No. Tell me what you need ahead of time, and I will help you find an in-state contract. I'll write the bid, whatever you want, I'll help you. But don't give me this because I can't say yes. And I don't want to be Dr. No. So again, it's if you can construct or install turf fields, synthetic turf fields, masonry, fencing, roofing, indoor carpeting, flooring projects. Another one, alarm systems. Okay, if it's just alarm, and I got this years ago from the Department of Labor. If you have alarm systems or video systems, and they're just replacing the sensor or the camera, and we're not running anything, we're not running wires, we're not doing any what they would call alteration, you're good. That's not construction. The moment you start pulling wires through a wall, the moment you start doing alterations, it makes it construction. We can't use the national co-op. So just bear that in mind. Oh, that's the end of it. Okay.
Sean, we did have another poll I'll
Sure.
throw up now. Actually, we have 2 that I think are pretty relevant to what you were just talking about. So first, does your municipality regularly utilize national cooperative purchasing programs? A few more seconds and I'll share the results. You should see mixed answers here. And then I
That's
think,
lower than I would think.
yeah. There was just one more that I'll launch while we have everyone.
So Sean, the big question of the day is how big is your volume of bid specs?
Oh, God.
Huh. I know I hit you up all the time. Like, did you do this? You're like, of course I did.
I've saved everything from going back to the early 2000s. It's like you, I've just I couldn't tell you. It's a lot, which is good. You know, as it was tough when I was younger and trying to, find stuff, big borrow and steal. But once you've done everything multiple times, and then you find, as you do, you've noticed probably too, you refine your work and it gets better. It's, you'll find something. I'll find something from 10 years ago. I'm like, oh, how the heck did I write that?
Kind of like that Google Sheets thing that we put together.
That's tremendous. Yeah, again, that's proprietary to us, but we're not proprietary to the world out there. So that again, you can't. And we've never said that. Hey, we're proprietary. It would fall on deaf ears. But some organizations would be like, oh, good, we'll hire you.
We just do the better job.
Well, that's the difference. You're not sure. Okay,
Great, thank you.
you're welcome. Yeah, look, at national co-ops, I've been beaten on DLGS. I'm like, will you please make this a point of emphasis at the state conference? And they made this here. We'll see. Sorry. No questions?
Usually a dog barking.
Yeah, my sensor that was Alexis telling me my backdoor sensor as well. I thought somebody was coming in the back door. I was like, oh.
I don't see any more questions. Sean, we appreciate everything you shared. That was great.
Yeah, thank you. I always appreciate the invite. I love talking with this group. Thank you guys. Have a great weekend.
Thanks,
Thank
Sean.
you.
Appreciate it.
Bud and John, do you want to give people a quick break and then we'll come back?
Yeah, you
10
want to come
minute
back at 11?
Sure, that sounds good.
Okay.
Thanks again, Sean.
Take care, Sean.
Thank you. Bye, guys.
Now, can you see that?
Yep.
Nice and bright. I like that background.
No, it's literally just one of the templates. I figured you like the childish colors, you know.
I do. Reminds you of Connect Four. John, you kicking this one off or am I kicking this off?
You were.
Okay. So let's kick it off. So we're going to go over the 2025 legislative updates. Most of you probably don't know, but Donnell, Matt, and I all serve on the League of Municipalities League Legislative Committee. It's a cool process. If you see the bills that are supported and opposed, that's where these come from. It's made up of 4 different committees. It's general legislation, land use and environment, taxation and finance, which I happen to be the chair of, and Matt and Donnell are members of that committee. And the 4th one is intra-municipal affairs. We meet about 4 to 5 times a year to review legislation and establish the league's position on the proposed legislation. Sometimes we send it back to the legislator saying, hey, we like the idea, but can you tweak it? Would you be willing to listen to us? And we get some great response. But the interaction amongst the committee members is fun to watch, especially when we get into some spirited debates. And I know Donnell's only been twice now and she gets a kick out of it already. But we thought it would be a good idea to bring back what we do in the committees and share it with you so you can see what kind of legislation is out there and being proposed. Donnell was nice enough to put it all in order for us in these slides.
Sure, you want me to jump right in, John?
Trying to,
Sorry,
Oh
I don't
my gosh.
understand.
Siri does not want me to jump right in. Sorry.
so all 3 of us have seen the legislation, so we're just going to kick it back and forth and tell you our thoughts on it.
All right, cool. So do you want to, yeah, I'll jump right in.
All yours.
Okay, great. So the first one we have is A 5014 from Assemblyman Stalky, sponsored this one. So this concerns county and municipal farm roadway improvement projects. This would be for expanding roadway shoulders to help relieve some traffic congestion with large, slow moving vehicles. I am the lucky CFO of 2 towns that have issues with this. So I can understand some need for fundings for things like this. We did request additional information from this one just because we had some concerns specifically about some of those DOT funds that I think a lot of us on here use for our regular roadways and road improvement programs annually. So we just wanted to make sure that there would be no reduction in that type of funding and this would be additional funding. So we just sent back to request more information on this one.
Perfect.
Next, we have A 5042, and it's also in the Senate as well. That is from Assemblypersons Lopez, Calabrese, and Sampson. So this will require state and local governments procure 5% of the goods and services from the central nonprofit agency for rehabilitation facilities for their set-aside program. So I think we all agree that this was a great idea in theory, but we don't really like it being mandated. We were concerned about regulations, so we did oppose this one.
So for those of you that don't know what the central nonprofit agency is, they hire disabled people, they train them, and then they put them out in the workforce. So it's a great cause, but as Donnell said, just don't force it on us. Let us do it voluntarily.
And what's interesting is about this group is that a lot of these bills, you know, when I got involved, a lot of these bills, some of them are really good ideas in concept, but they don't have the detail or they didn't think through the process completely. Or we have questions on side effects and symptoms of whatever the bill is. So while a lot of times I'm like, oh, this is a good idea initially, the group's fairly large, and once people start kicking around ideas, quickly downsides or problems come up. How many people is on our finance commission, John?
40 or 50?
Yeah, so it's a fairly large group. The times I've been there, there's been between 20 and 30 most of the time. So
Last time we had to bring extra tables in, Matt, we filled it.
right. So it's having that many kind of brains thinking about, you know, whatever's being proposed is effective because a lot of times, like I said, I'll think, oh, this is a great idea, but you don't think through the whole process.
Which actually is a good point, because each committee has about 40 or 50 people, so the committees weigh in on what our position is before we end, and then they merge all 4 committees in one big room, and each chairperson has to present the results to the full room. And the rest of the room can challenge your position. So it really is a cool process. I think last time there were 4 challenged from the floor.
Right.
Okay, so next up is A 5175. So this would reinstate the automatic COLAs for retirement benefits for PFRS members. The calculation is based off an amount up to $75,000 from their annual pension benefit. Obviously, our concern, and I'm sure we could briefly talk about, we could probably go on, not briefly, talk about this and talk about how the pension system is already an issue. So we would like to see something else done. And considering the municipalities are already paying 37%, which is what we were charged this last year, it's not really in the cards. We oppose this one.
So we also discussed during this portion that the statutorily required funding ratio to consider a COLA should be 80%. So as a result of that, I went and I got the actuaries report to look at
These are really interesting.
So this is just from the state side. The state funding level is in this funded ratio column where it says A divided by B. They're in the 40s and dropping, which we all thought was interesting. The local side is in the 70s. I thought it was worse than this, but it's in the 70s. But if you remember back in 2020 was the 20 and out rule. So we were at 71.35. You saw an immediate drop. It's come back a little bit, but it's still nowhere near 80%. So as Donnell said, why would we break it before we fixed it? So the interesting part about this is several years ago, before PFRS was able to pull themselves out and become their own fund, the state was looking to merge the two to recapitalize the local funds with the state funds to make it appear that they were better capitalized in the 60s rather than the 40s. But that was a cash grab. Never happened.
So Senate Bill 3811, this is sponsored by Senator Beach. So this goes along with what Matt was saying before, that there's some information that's missing on this. So we just needed some clarification and referred it back to legal. It just revises the definition of contracting unit to include state authorities and agencies. So we just, again, need more information to see if this pertains to municipalities as well, to really give our input on it. Next up, we have Senate Bill 3849. So this, it's pretty straightforward. It increases the bid threshold to $22,000 without a QPA. We did suggest that this be reviewed when the QPA threshold is reviewed every 5 years, rather than it being done like this, to have it reviewed every 5 years to bring it up to what we do with QPA thresholds.
And generally,
and that's supported.
If there's legislation that is permissive and allows us greater flexibility, our task is to approve it. But still, we wanted to clarify this.
Right. So next, which I loved this one actually, and we had a lot of good discussion on this. Like John and Matt both explained, the individuals, we have a large group of individuals, and they kind of come from all walks of life. Some of them are just elected officials, newly elected officials. Some are former CFOs, retirees, retired former public officials. So this came up. This was basically taking our local finance notices that we get every single year and pretty much putting the extended dates for our introduction of the budgets and the AFS approval of the budgets, all that other stuff, and audits, putting that into law to push that forward. If you just go to the next slide. This gives a little bit more information on this. So it also allows us to increase our temporary budget to 35% for counties and municipalities. It obviously remains the same for the state. And the part that was really interesting that kind of got a little bit of a heated debate, which I enjoyed, were the fines being increased for governing body members. I don't know. I'll just be honest about my own personal opinion. I love this. I think that we kind of all talked about in this group that, and we kind of explained to the not public officials, to the elected officials there, that we're all kind of faced sometimes with certain governing bodies who just don't want to push through a budget as a way to stick it to somebody else. So this is a nice way to remind them that they have a job to do and to ensure that the business of the township gets done, and that comes first. So I thought it was really important. I come from I have 3 different municipalities, and all 3 are very different. And one might have to do something like this at some point. So it's nice, it's nice to have something to point back to, that this could be an issue, because I think the $25 a day is not really enough or significant to them. And of course, it keeps with they are fined individually. The township is obviously never fined. It's the individual council people or committee people that don't push things through. It also affects the vacancies for the CFO, tax collector, public works manager, and clerk as well. So they would have to they'd have to fill those vacancies within 90 days or otherwise be fined. I like it. I think it means we don't have to wait for local finance notices to come out for those dates.
And the rub at the committee, which is why there was debate, is this is being done to fix what the state screws up, right? They keep dragging their feet. We have to wait for the budget address in order to do our budgets. So that was the rub, is why can't the state just get their act in order and do what's right? But we're not going to hold our breath on that one.
Yeah, we said good luck to that.
And some of the pushback was like, well, why are we changing the statutory dates? Why can't you have your AFS on time? Why can't you have your budget adopted on time? And that's, valid in concept, but in reality and in practice, it's not always easy to get things done on time, especially when you're looking at your budget on time. AFS, I think you can make an argument, could be done by February 10th, or should be done by February 10th. But the budget is dealing with things out of our control. So it's not necessarily fair to penalize us if we're not within those statutory dates.
Yep. Okay, so Senate Bill 3997. So this was sponsored by Senator Steinstein. Sorry if I butchered that. So this essentially removes all other tiers in pension into tier 1, and it's her effort to attract public employees for both PERS and TPAF. So it also moves everyone that's a DCRP enrollee into PERS. They do have the option to opt out of PERS. And their service years do count for service, but not towards the pension benefit calculation, which was interesting. And then another point that I found interesting, which I put here, was that anyone receiving long-term disability under DCRP would auto-qualify for accidental disability retirement allowance, which is not a small amount. And then we did another instance where we request to hold this one. We do believe that reform is needed. We did acknowledge that it does attract new people, because obviously tier 5 is not very attractive considering the former tiers in comparison. But we would really need to know the finances and have sort of an analysis on how really, again, are we going to fix the problem here? We're just going to let it continue on.
And they didn't quantify the financial impact, which was our concern. By merging all of them and they're funded in different ways, what would that do to the system?
Yep.
Yeah, this is another example of us just needing more information, because I think this would help drastically in recruitment of qualified individuals. It would help keep the qualified individuals in practice now. But what's the financial impact? They didn't provide it. We don't know. It's hard to agree to something or support something where you don't know the whole story.
You know what? Before I get to the next one, I realized I didn't do the introductions. So for those of you that don't know Danelle, she is an experienced CFO serving multiple New Jersey municipalities, including Kingwood, Waterford, and Vernon townships. She has also worked in Powhatan, Mahwah townships, and she brings extensive expertise in municipal budgeting, financial oversight, long-term capital planning, and regulatory compliance. With a background in financial consulting and public administration, Danelle specializes in optimizing financial strategies, managing multi-million-dollar budgets, and implementing sound fiscal policies. She holds her CMFO designation from Rutgers and a master's certification in public administration. She also has this strange obsession with a market down in Hamilton that she's always talking about. I don't know, Danelle, did you want to tell them about this market so that they don't miss out as well?
If you're ever, it's not in Hamilton, it's actually in Williamstown. You should go to it. Thanks.
So Matt Laracy is the CFO of Milburn Township in Essex County and the current president of the GFOA of New Jersey. With a master's degree in financial accounting from Rutgers University, Matt began his career in public accounting before transitioning to local government finance. Matt is a CPA, CMFO, and a QPA, bringing a strong foundation in financial management and expertise in strategic planning and fiscal oversight to the public sector. His leadership and commitment to sound financial practices have helped municipalities navigate complex financial landscapes effectively. So here's a fun fact. I knew Matt's father, Paul, before I met Matt. I've been working with him since 1990 in the GIF world, up until he retired. So while teaching Current Fund 1 in the fall of 2014, Matt, this kid named Matt Larissy was in my class. Small world.
Matt, I think we took that class together, actually.
That feels like a long time ago. It's not too long ago.
Not too long ago.
And to
We'll
those
convince
younger
you.
CFOs on the or financial professionals on this webinar right now, John Reinhardt threw me into GFOA activities and webinars and seminars left and right when I was younger, but it helped my career drastically. I'm the president of the GFOA now, so just don't be hesitant if people ask you to help. Just say yes. Saying yes kind of even if you're unsure about it, saying yes can get you pretty far. And only, you make more connections, make friends. It's always a good thing. So just be encouraged to participate, even in something like this. If you have an idea, I'm sure John would appreciate, both Johns appreciate the recommendations on topics or speaking. So don't hesitate, everybody.
All right, so now that we finished the intros.
Okay, we'll jump into this one. So this was sponsored by Assemblywoman Ramirez. This would authorize temporary property tax exemption for certain home improvements not to exceed $100,000 in assessed value of the improvement. The general consensus is that the state already has programs in place, abatements, programs for this. There were concerns about doing this and you'd be subsidizing developers. I know that a lot of people do renovations to homes and then, put them out as Airbnbs and stuff. So it's not necessarily just a single person's home. I can be, from my perspective, I just want to put this in, from a township that does annual reassessments, I don't like this at all. I don't like the idea of having your taxpayers subsidize other people's improvements. Although, some people just did their kitchen, so they might redid their kitchen, so they might enjoy this this non-inclusion in their taxes in the future. Obviously it would affect all of our C1s, CNC1s, which we use each year when we do our budget for tax purposes. So we did oppose this kind of for obvious purposes. I don't know if John opposes it though, personally.
There was some debate as to does this encourage people to improve their homes, and there's just a slow lag or 3-year lag on being able to increase the amount that they're assessed. The assessors in the room were adamantly opposed to it. Says the record keeping for the other abatement programs already is a nightmare. This would just create another layer of administrative burden.
This one was a weird one. So this actually stems from a case last year. I didn't put this on here, but stems from a case last year for someone who was ticketed for not having a beach tag while he was surfing. I think that there was probably more to that story, but obviously it has become a bill. So it prohibits beach tags for access to beaches below high tide for recreational purposes. So our question was really regulation. I mean, like how do you enforce a high tide? What's considered recreational use? If you bring your kids to the beach and they're not in the water, does that mean you need a beach tag, but they don't need it? I don't know. It gets a little bit nuts. I think it's a little overreaching. We did oppose this, and obviously for financial purposes, it's going to decrease revenues for municipalities and the beach communities, and there were already a ton of beach communities that opposed this legislation, so we did as well.
So actually, he wasn't ticketed; he was arrested.
He was arrested.
He was arrested
and ticketed for not having a beach tag. They just added it to his rap sheet, I guess. It was a list of other things, but. Next is 4816. Oh, wait, I missed it. Sorry. 5373. So this one's really interesting. I think it was the only one that we fully supported in this last round of the legislative committee that we did. So this broadens the ability for the municipality to take over private property that is considered abandoned, vacant, or subject to unpaid taxes. So without having to go through a lengthy process. So they would need to meet 4 of a bunch of criteria. So just a couple of those, I'm not gonna go through all of them, but accumulation of newspapers, circulars, flyers, or mail on the property, absence of window treatment such as blind curtains or shutters, absence of furnishings and personal items, statements from neighbors, people just attesting to the fact that nothing's been done. Obviously the property looking derelict, windows and entrances to the property that are boarded up or closed off, etc. So they would not be considered abandoned if properties under construction, if it's occupied on a seasonal basis, or if it's secure but it's subject to probate or another title dispute. So we recommended that this also, because the bill's kind of written where it just talks about buildings, as you just heard, some of those things, windows, doors, etc., to also include properties that do not have buildings. I have a couple of towns that have vacant properties that are really, really unkempt. And there are some things in place where municipalities can do things, but if and we could take care of it ourselves and then build them, but that doesn't really help with the issue at hand. It gives these municipalities the ability, obviously, to take them over, sell derelict properties once they take them over, without having to go through the Abandoned Properties Act, tax sale law, or in rem tax foreclosure act, which again can take time. And we did support this one. Next is Assembly Bill 5394. So this would require certain state funded construction projects to utilize 10 to 15% of any of the plastic materials that are used on site, to include 10 to 15% of post-consumer recycled plastics. So we feel good about doing things like this. I think we can say, oh, that's nice, we're using recycled construction things, but our concern was the 25% or more mandate. So basically, if the cost of the project is increased by less than 25% by using this, you still have to do it. And we did not really support that. I think we can all agree, if we have large construction projects, even a 5 to 15% increase is massive. You could be talking about hundreds of thousands of dollars just in those percentages. So we opposed this. There were a couple concerns about where the post-consumer recycled content is coming from, what's actually in that. It's been decades, or only just now learning about, forever chemicals, carcinogens, etc. And then also what kind of in line with that, what kind of research went into that, and then also what kind of regulations would be put in place to prevent any issues with those post-consumer recycled plastics. So we did oppose that again.
And it was brought up that you can do this locally. If you want to do it, you change your ordinance and you can require it on your own. But since it was restrictive, that was another reason why we opposed it.
And Senate Bill 4069, this was sponsored by Senator Singleton. This would require a cost-benefit analysis for every abatement exemption, and furthering the analysis that a municipality already does, and including counties. It could bring up issues that aren't maybe the reasons why a specific development would be receiving an abatement or an exemption. So we did believe that this could cause issues with incentivizing redevelopment. There were a couple concerns, John, I think, about school revenues. I think schools and sometimes even the public, they kind of express some distaste for pilots because they don't really understand it. I think a lot of people get concerned about if there's an increase in school enrollment, but schools already have paths to address any enrollment issues and increase enrollments to help with their levies. So we felt, obviously, we support pilots and stuff like that. So we did oppose this bill requiring additional, extensive analysis for any of the pilot, or, any tax abatements or exemption projects that would be in municipality.
But one of our newest members on the committee was offering up that we should offer an automatic 5% to the schools like the counties get. So we thanked him for his comments and said that was his last meeting. So some of the debate was over the schools looking to get this, and they've been ramping up their efforts. But if you've ever gone through a school budget, they develop their budget, they tell you what they need, and we give them 100%. So now they want to dip into the pilot revenues when we're using it to incentivize blighted areas getting fixed. They get their money, they don't need it. there are many towns that do it in the form of grants where they offer them money back but not making it part of their operations, making it a one-time donation for something. And I think that's probably more appropriate.
Okay, next, Senate Bill 4111. So this establishes an alternate calculation of retirement benefits for members of TPAP and PERS. It also requires notification to beneficiaries for calculations, which I thought was interesting. And then the beneficiaries and members could review and approve a recalculation of benefits off of the last 3 years, off of any 3 years highest salary. And then any member retiring after January 1st of this year could have their benefits recalculated. Again, it was one of those pension already has enough problems. We are opposing this.
Keep your hands off the pensions.
Yes. And lastly, the one we went over, this would allow, this one was a little bit heated, I think. This was Senate Bill 4250 from Senator Bucco. So there's been a lot of discussion, obviously, on sinkholes, collapsed mine shafts. If you're from northern New Jersey and you ever have to take Route 80, I'm sorry that you cannot be on it right now. Route 15 is a disaster. Route 23 is a disaster as a result. I think we can all kind of see why people, municipalities want to use this. And I actually, during the discussion, I kind of supported use of this. Just because there are some municipalities that have large open space funds. And, I think if it gives the opportunity, this does require to have an ordinance where you could use open space funds, but you're required to have an ordinance passed. Obviously, I think it's a longer public comment period too. I think it was like 28 days, similar to like the budget. I think you introduce it and then it's 28 days later is when you could adopt it. So it gives you a longer period of time to make comments on the ordinance. We did oppose it. We felt that the Open Space Trust Fund, obviously, as established through voter referendum, voters, when they voted on it, however long ago, wanted those monies used for specific purposes. So we felt that it kind of violated the voter trust.
I think the one suggestion is if they really want this, to change the legislation now to allow it to be expanded to that and then put it back out to referendum to get the voter approval.
It's just interesting in this time, like with everything going on. And I know there was another bill, I wonder if that's going to come to us, but there was another bill that was just introduced Monday. I think all of the businesses and stuff that are off Route 80 in that whole area, they've been talking to them and they're losing anywhere from 10 to 40% of their revenues right now. So I know that they just introduced another bill Monday to provide tax credits for those businesses and then some additional funding for employees who haven't been able to work either.
Now she's just showing off.
I'm gonna
What Google can do for you.
Sorry, Danelle. I'm gonna jump in with a polling question on your guys' topic. Does your municipality actively engage with the League of Municipalities for legislative support? And I'll share the results in a couple seconds.
It worked. There it is.
All right, you guys should see the results now. And before we switch, I'll just launch the second poll on this topic. Which is, are you familiar with the most recent legislative updates impacting local municipalities? Guess now they should be after that.
Well, I think the three of us discussed that this would be a good one for us to bring back if the roundtables, as we have updates, just to let everybody know what's moving, what's not.
Right. All right, and you guys should see the results now. Got most of them. Thanks, guys.
Matt, can you see the slides?
Yes.
Okay, good.
All right, so this is just going to be a brief update of the last 6 months of local finance notices. They're a good resource for us. Lately, not coming out on topics that may be more beneficial for us. there's been a lot of ambiguity lately, but it's still a good resource, and where all the information on budget extensions, cap exceptions, and all comes out. So if you don't have this link at the bottom there saved, or Google memorized, you should. All right, the first one here, I'm not sure how, some of these aren't as applicable to maybe those on the call, but this sets the cap of what is allowed to be paid towards volunteer firefighters, companies, and commissions. The cap was set in 2015 as $150,000. It's supposed to be updated every 2 years in accordance with COLA, so this brings it up 2.5%. Into the 2025-2026 fiscal year to $165,564. And I learned, going through these, I learned a few things where the Board of Fire Commissioners must use at least 50% of the municipality's annual appropriation for the purchase of fire equipment, materials, and supplies, and that the board has to provide the municipal body an accounting of these funds. Which I was not. I knew they had to provide something, but I didn't know the 50% threshold. So, that's 2024-14.
Be interesting to see how many people actually go out and review the expenditures of the fire companies.
Right. I highly doubt that's happening.
I know when I was in Wharton, we made them buy out of our budget, so we knew everything was compliant.
That's a little bit more. I would say that's probably more common for what I've seen, at least. All right, 2024-15 is concerning municipal and county budget cap information. So what this did was the COLA for 2025 budgets is 2.5%, unless action is taken by the governing body to increase to the 3.5%. For a municipality, that's an ordinance that a lot of us do every year automatically to increase our COLA to 3.5%. But for a county, it's just a resolution, which is sort of interesting.
But they make us do it twice.
Okay. So in effect, it's an ordinance at the end of the day. It must be adopted by the majority of the full membership of the governing body, which I've actually had issues with before when certain governing body members may not understand this 100%, thinking that you're just going to go up 3.5% every year. And they think it's a negative thing. So sometimes this is met with some resistance. And it excludes municipalities from cap increase referendums, excludes municipalities who have referendums. What this also did was codify the group health insurance exclusion, which is limited to the amount appropriated that is 4% of the previous year's expenditures. What it did, and what's interesting about this is the two caps are treated differently. So the appropriations cap, it allows for a 12.4% increase. And for the levy cap, it allows for a 14.4% increase. And this also just further explained the garbage recycling and workers' comp exclusions that were from the prior year. (2024-16), more concerning fire district budgets and elections. This is telling them that they must submit their budgets through FAST, which I think they were a little bit delayed as compared to municipalities and counties. Each fire district has to submit it to the local division of local government 60 days prior. The municipal approval of elected commissioner compensation must be completed, even if it's unchanged. So they must certify elected official compensation, even if it remains the same each year. It talked about emergency appropriation procedures. It talked about the 14.4% cap exclusion. And it talks about financial capital appropriations must be approved at an annual election or special meeting. And it also talked about transmittal deadlines. Those of you with utilities, you've been doing this for a few years now, but this local finance notice actually had more detail than previous years. So this was an update to LFN 2023-09. Residential customers can avoid shutoff from November 15th through March 15th for non-payment, water, sewer, and electric service. The BPU has similar programs for investor-owned utilities, so it's not just municipalities. This does not apply to emergencies, meaning that if you need to shut off somebody's water due to an emergency, you can still do that. You know, it doesn't stop you from doing it for safety and emergent reasons, just for non-payment. There's a whole list of eligibility requirements. Who's eligible for this? And it's basically those if they participate in various federal, state, or local assistance programs. Like I said, there's a whole list of programs. You know, and you know, generally, if someone's in this situation, they're probably on one of those programs. If somebody's already turned off outside of this window, and you know, November 14th hits, you have to turn them back on by November 15th. So it's not just turn-offs during this. It's if they're turned off prior, you have to turn them on. It does not affect the enforcement of liens at all. And there's certain notices that must be sent and included on bills prior to November 15th. Now, I am curious. I don't know if people in chats or anybody on the panel want to speak up, but I've never really had an issue with this in my municipalities, but I am serving mostly in higher income municipalities that may not come across this as much. But I don't know how widely applicable this is to everybody else, and are they running into this where they're turning people back on during this window?
That might be a good question to throw up for everybody.
I can add it as a question. Can you just repeat the question?
Yeah, I guess just how impactful has this winter termination program been in your municipality?
All right, I will put that up in just a second.
Donnell, do you deal with this at all?
I don't have any issues with this.
All right.
So yeah, not in Vernon or Waterford.
Yeah, they dig their own wells.
We're finally getting real water in town center in Vernon.
The wall and online certified payroll system. July 1st, 2024, the prevailing wage threshold is $19,375 for municipalities and $2,000 for other public bodies. The Workplace Accountability in Labor List, The Wall, which is a great Pink Floyd album. Also, The Wall was when I was in grammar school. If you were, you know, not behaving at lunch, you couldn't go to recess. You had to sit on a wall, which probably isn't allowed nowadays. But when I read The Wall, I think about Pink Floyd album and my time spent on the physical wall, brick wall in grammar school. It's a good name, The Wall, all capitals. The state makes it, so it's, you know, it sounds probably worse than it is. But The Wall is a list of any person found in violation of state law, state wage, benefit, and tax laws. So if you're in violation, you get placed on the wall. TMI. Jim Burnett's telling me that was too much information. I didn't go into what I did to get on the wall, Jim. Just saying I was there once in a while. A person placed on the wall is prohibited from contracting with any public body. There's no dollar threshold for the wall, so you can get put on this list for, you know, minor monetary sum. Effective August 15th, 2024, contractors or subcontractors performing on prevailing wage projects must certify their payrolls through this New Jersey Department of Labor hub. I have not used this hub. I think I have a login, but it really should be coming from the contractors and subcontractors. Online submission has to be within 10 days of the date that the wages were paid to a worker, and it further defines public work, which is it's a pretty wide definition. John or Donnell, have you guys kind of used this online portal at all, or helped contractors with it?
No, but I did want to comment on I mean, it's been the same for a while, but the prevailing wage threshold, I have no idea why. I mean, maybe John knows or someone else on here why they never included authorities. So I'm the CFO for an authority in Vernon. And it is horrible trying to find anybody because everything, I feel like literally everything we do is subject to this. The $2,000 is like nothing. We've done some shared services with the township to like address this because we've gone out for you know, quotes and stuff, and nobody has the license that they need to have, or you know, the dollar amount is so high with prevailing wage, it's just ridiculous.
Same thing with counties, stuck with 2,000.
That's terrible.
That's rough.
I don't know why did they not, I don't understand why they didn't. I wish we could recommend our own bills at the league legislative committee.
Hey, Matt, before we move on, I can launch that polling question.
Great.
Okay, everyone should see it now. How impactful has this winter termination program been in your municipality? And I guess too, like they were talking about, if you guys had any specific issues, feel free to put them in the chat.
In one of the previous towns I worked in, we would turn people off from time to time, or at least threaten it. But we, in general practice, wouldn't do that in the middle of winter. We might threaten them to try to get payment with shutoffs, but in general, that wasn't our practice anyway. So I'm not sure if many people were just turning water off in the dead of winter or not. Okay, that makes sense.
Thank you.
So Matt, this one is county specific, 2024-19, comes out every year in around November. And it's a state mandate, state pay, because they set the compensation for the constitutional officers.
All right, so this 2024-20 is one of our favorites every year. This changes the statutory dates of transmissions of the budget in AFS, which we already talked about during the review of legislation. And of course, it's always the next regular scheduled meeting of the governing body, which is helpful. Adopted anytime within 10 days of, you have to adopt anytime, you can adopt anytime within 10 days of receiving the director's certification. It's currently a 25 per day fine for governing body members who do not comply. And this year, the exam group is group 2. So if you're group 1 or group 3, you may be eligible for local exam. The list of if you're eligible is included in the local finance notice. What this also talks about is the Water Quality Accountability Act, capital plan, and plan which has to be filed by March 15th. And what the state started doing last year, and they're saying they're going to do this year, is if that plan does not match the capital budget that I think a lot of towns probably just ignore or just throw some numbers into in your state budget document, it needs to match what was filed in this WQAA report. So if you did not do that yet, make sure you do that, because if you're under state review, they make you change it, which was interesting last year, because I said, how do I amend a capital budget? It's not part of the real budget, in between the introduction and adoption. And they said, just change it. Well, okay. But anyway, get ahead of that. The amendment process cannot begin. They're highlighting that the amendment process of your budget. So if you have a slight amendment that the state makes you make, or you're making on your own, it cannot begin until the public hearing on the introduced budget is held. So I think I've seen some towns kind of get that out of order. The state usually doesn't make you then do it again, but you're having a public hearing on what you introduced, and you can make the minor amendment after that. This also includes the municipal aid notice, cap reminders, and library budget notice. And it states that the current year budget plus 3 prior years must be on your website. That includes the user-friendly budget. All right, LFN 2024-21R. It goes through appropriation cap exceptions for our 2025 budgets. It has the additional appropriation cap relief in excess of 3.5%. It talks about garbage and trash removal and disposal costs, which is restricted to those who did not use it last year. Workers' compensation insurance, general liability insurance, which includes property, casualty, and cyber. And a lot of us are in GIF, so those are all combined. The additional amounts from these that are moved outside the cap go to sheet 20 on your budget. It also tells us which you can find your templates, and the levy cap workbook template, which most of us have probably done already or in the process of introduced, if not introduced already. And it just sets the FOCA codes for those exceptions.
You done?
Yes. 2025-01, which is usually the first local finance notice, sets the levy cap referendum procedures for the year. If you needed a referendum, you probably already looked at this, hopefully. So, this is kind of after the fact, but there's certain deadlines for advertisement and public notice. It's based on election dates. So your form of government, form of the school district impact, the method for a levy cap referendum. Municipalities with under 500 people can just hold a vote by mail referendum, which I found interesting. I'm not sure. There's probably only a handful of municipalities under 500 people. But there's certain wording you must use, and you must have a plan to take immediate action if the referendum is defeated. So if you think you're going to have a referendum on exceeding the caps, you have to be able to take action right away if that gets rejected. Otherwise, the states can have an issue. 2025-02 is a LoSAP CPI adjustment that comes out every year. So there's a minimum of $100 and a maximum of $1,150 per year. Referendum must occur to increase award amounts past the base amount. Time-to-time increases based on the CPI, you can just award those via resolution. But if you want to do automatic increases, and that wasn't in the original LoSAP ordinance, you have to amend the ordinance. The increases for this year are 3.4%, and that's for a municipality and a fire district. And the maximum allowable by year and the annual CPI, they include in a large table all the way back to 2000, which is, if you have this program, is interesting to look at. (2025-03), it sets the transitional aid application process. Again, it's too late now. If you for most municipalities, if you need this, but the application deadline is March 7th, and you have to notify the division by February 21st. Fiscal year applicants have to notify the division by August 25th, and the deadline is September 29th. There's a whole list of requirements. New applicants have to attend orientation and training on this. Again, if you needed transitional aid, you probably did this already. So we brief on this one.
Matt, there was something in the Q&A. Somebody just made a comment that they passed a resolution to not shut off. That was interesting. The water.
Oh, interesting. So they're not going to shut off people during just that window or in general?
They just said they passed a resolution. That was all they said. Oh, here's one more. That was it. All right.
Yeah, and most of the time, I think the shutoffs are more of like a scare tactic to get people to pay. Most people don't really want to shut anybody off, but sending those notices is really impactful in terms of getting people to finally come and pay.
I had two of the public works guys when I worked in Morton used to enjoy it.
Right. You send your biggest public works guy out there with a shut-off notice, and payment sometimes comes in shortly thereafter. Let's see here. I combined these two. There's two local finance notices, 2025-04 and 2025-07, regarding the annual financial disclosures. There's plenty of information out there on this, but this is the financial disclosure statement that everybody's has to file by April 30th, or within 30 days of taking office if you're after the deadline. Failure to file can result in a fine up to $500. The roster of who has to file has been updated, so that's included in there. And it's very widespread, so likely if you're any sort of public official or on some sort of board, you have to file. The instructions for online registration and filing are included in this finance notice, and there's certain exceptions that they detail due to Daniel's Law, which is interesting. I think it says Danielle's Law. If you have multiple positions, you do not file multiple times. They give you a PIN, you add that PIN to your current login, and you can file all in one swoop. So if you get a new position, even if it's temporary, you should get a PIN from that entity, and you add that to your profile. GIFs are deemed as separate local government entities, so anybody who's on a GIF has to file, who's on a board or a chair of a GIF has to file. So that really, a lot of them maybe aren't used to it, or they're already filing if they're the CFO or elected official already. So, but that is an item to note. Has you guys ever had an issue with somebody not filing?
Oh, yeah, I chase people down every year.
We had a planning board member one year who did not file. It was when it first came out, actually two of them, and the state fined them.
Really?
Actually, Shannon Hudak was the local finance board attorney at the time.
Okay.
So we wrote a check from the town and paid the fine. So she returned the check, said, the town is not permitted to pay a personal fine. I said, great, then I'll pay it and then I'll get reimbursed. She didn't like that one either.
Yeah. All right, 2025-05 was the state aid certification. It certified the amounts in the payment schedule. This comes out every year. It references local finance 97-6, which describes the basis of the original ERT program, which is interesting if anybody wants to read that. It's kind of interesting to look back to then. I don't think what they initially wanted to happen is happening, but that's okay. Final aid payment schedule will be provided in January once the state's budget is certified. This also certifies the watershed offset aid and the Garden State Trust aid, and it gives some details that if your municipality or entity changed banks, there's certain agreements that you have to file to get that money directly deposited into your accounts. So that is important to note if you're changing banks. Let's see, there's a note in the chat here. I had someone who was retiring and refused to file. They left the state and told the state to come find them. That's good. 2025-06 is updated property tax bill language. There's not much to say on this basically, but there's state offset calculator language must be on there. The property tax relief program information must be on there, and it gives you the specifics behind that information.
That's it, isn't it, Matt?
I think that's it for the local finance notices. That's everything in the last 6 months. Like I said, a lot of it is the stuff we expect each year, and there hasn't been too much in the last 6 months that's changed the way we do our jobs, which is maybe a good thing. But
so we did talk about doing one more adding to the session. If I can figure out where I am in this. Matt, had you had a chance to look at this?
yes, oh, the fast, the fast portal. Yep.
So it's not only just the fast portal, but the state has been doing a great job of sharing data. They're starting to put all the audits, the AFS, the debt statements in one central location.
Right.
There's also a bunch of information on pilots and tax abatement programs. There's a toolkit, there's a disclosure. Not sure if everybody was aware that this is here, but you just scroll below the regular fast login and it's right next to it all. But it's
there's a lot of data in there. I stumbled upon that a week ago, maybe. And then the fast portal is also interesting. Now, a lot of that, the fast portal is relying on and the user-friendly budget portal has a lot of information. So you can compare yourself to different towns, see what other towns are doing. All the user-friendly budget information, though, is dependent on the town that you're comparing to actually entered it correctly on the user-friendly budget, which isn't always the case. I found a bunch of things where I'm like, no, I know this isn't the actual numbers, but no, there's a lot of data in there. People should know where this is, and can snoop around today to see what's in there and how it might help you.
They're doing a nice job with that. The other one that I thought was a pretty useful site was, where am I going? See if I can find out without bumbling around too much. DCA also puts out a whole, that's that one. 1 second. Bunch of property tax information where you can go back pretty far. They give it to you in Excel, they give you PDFs, they give you a bunch of options, but there's a ton of data out there. Not only your rateable base, you can see growth, you can compare yourself on a a county equalized basis and then on a state equalized basis. And they adjust your tax rate. So if you're trying to compare yourself to another town, it makes it a little bit easier to do.
Yeah, that's great. All these resources are good because especially during budget season and presentations, some governing body members want to see how do you compare it to other towns, municipalities. So this data makes it easier than going to each town's website, trying to pull the information wherever they keep it. Each town's totally different. If they keep up this initiative, it'll be great.
I know it's helpful for me because I'm always asked, well, how do we compare to the other counties?
Right.
So usually at the bottom of these analysis is the county recap, which makes it a great resource. John, did you have anything else? I know that was pretty much it for our slides.
No, we just have a question pop up in the Q&A. Filing a financial disclosure statement since I'm the CFO of a municipality. Do I need to include the FDS? In the FDS, my role as commissioner to the Morris County JIF?
No, you actually do a separate one for the JIF. They should give you a PIN.
Okay.
I'll just jump in and do the last polls on this topic, and then we're done with that. How often does your municipality refer to local finance notices for guidance?
So Katie, I had a couple people send texts to me asking if we're going to share the PowerPoints. I am going to send her the updated PowerPoints as soon as we're done, and then she can.
Yep,
You put them on
I
your
can
website,
include
or
them. Sorry, John.
you put them on your website?
Yeah, we'll put them, include them on our website, include them in the follow-up email. So as long as our presenters are okay with that, which I think everyone seemed like they would be. So I'll just confirm, and we'll also send the recording. We've been recording today, so.
Hey, do you prefer PDFs or the PowerPoint?
PDF is good.
Okay,
Thank you.
you're welcome.
All right, I think we're good then. on
Katie, I know
polls,
we're
so.
supposed to go until 12:40 to get the full 4 hours of credit, but Bud and I were going back and forth. 11:50 is 3 hours of credit. So that's what today's going to be. We thought we'd be able to stretch it out for another 40 minutes or so, but I don't think we're going to be able to do that today. Which some people might be very happy about.
I had a 12:30 drop off, so I'm good.
Yep.
Okay,
All right.
I don't see any more questions. Nope, I don't.
Nope.
All right, yeah, if there are no more questions, I just want to remind everyone, like John mentioned, we'll send out the presentations, the recording. There'll also be a follow-up survey today that should appear in your browser when we close out here. Just complete that, that's for your credit, but we'll also include that in the follow-up email if you don't have a chance to complete it today. And I just want to say thank you to everyone who was on the call and to our panelists. I think everyone found this session very valuable, so
I think
thanks.
it's amazing that Chris Botta stayed on the entire time, and he looks like he's excited about it. What did you think of the rest of it, Chris?
I did drop off a little bit, but I thought it was very good. I'm filing those local finance rules are difficult.
Yeah.
That's a
Look,
testament to you guys.
no, I just want to echo what Katie said. Thank you very much for joining us today. And thank you again to all the panelists. I know you guys and ladies put a lot of effort into the presentations, and we greatly appreciate it. We'd love to hear more questions and stretch these out a little bit longer over time. So next time, just come with a couple of questions, throw them at us, and let us deal with them. It is a round table, and we'd like to get everybody's experiences on the table as well. So again, thank you all for joining, and thank you to the panelists that helped us out here today.
Thanks, everyone. Have a great weekend.
Thanks, everyone. Enjoy the
care.
weekend.
Good weekend.